Good morning, everybody. Happy Wednesday. Welcome to TCF Live. I'm Dan Soul. I'll guide you on this 3-hour journey through Courtlandia. We're jumping right into the deep end of the pool. This is Judge O'Donnell in Lake County, Ohio.
In open court with their attorney, Nicolette Tomasic, the state has extended an offer for the defendant to plead to count 3 of the indictment, count 3 being a failure to comply with an order or signal of a police officer, a felony of the 3rd degree. It's my understanding that the defendant will accept that plea. The state would request a pre-sentence report and a victim impact statement prior to sentencing.
Ms. Tomasic?
That is correct, Your Honor, and along with the pre-sentence report, we would also request a drug and alcohol evaluation. Thank you.
Mr. Rivera, how old are you?
55.
How far did you go through school?
2 years of college.
Are you a U.S. citizen?
Yes.
Are you able to read, write, and understand the English language?
Yes.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
No, Your Honor. Well, just my blood pressure medication.
Have you ever been diagnosed with or treated for any mental illness?
No, Your Honor.
Did you get a copy of the indictment?
Yes, I did.
It's my understanding you're going to plead guilty to count 1, failure to comply with felony 3, and the remaining counts will be dismissed at the time of sentencing. Is that your understanding also?
Yes, Your Honor.
All right, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you some questions. If you don't understand the question, stop me. If you want to talk to Mr. Tomasic some more, let me know, and I'll give you more time. Do you understand that?
Yes.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine those witnesses. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them come and testify. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the right to testify at trial if you want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford to hire a lawyer, one will be provided at no cost to you. Do you understand that?
Yes.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford a copy of the transcripts, they'd be given to you free of charge. Do you understand that?
Yes.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes.
Do you have any questions about any of your rights?
No, Your Honor.
Do you still want to plead guilty to count 1?
Yes, I do.
You understand by pleading guilty, you're fully admitting your guilt to the charge.
Yes.
You understand by pleading guilty to this felony, you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control.
Yes.
Count 1, failure to comply, is a felony of the 3rd degree, carries a 60-month maximum prison sentence and a $10,000 maximum fine. Do you understand that?
Yes.
Are you presently on post-release control to the parole authority?
Yes.
And how much more time do you have on post-release control?
I was scheduled to get off this year, Your Honor.
Do you have any idea, Mr. Knopf, how much time he has left?
I do not, Your Honor.
All right. Do you understand that in addition to being sentenced on this case, on this failure to comply, I could also sentence you to prison on your post-release control violation?
Yeah.
And I could give you, if I sentence you to prison on that, it will be a consecutive prison sentence. Do you understand that?
Yes.
The maximum I could give you on the post-release control violation is the greater of 12 months or the time left under post-release control. Do you understand that?
Yes.
Do you have any questions about that aspect?
No, Your Honor.
Do you understand that your guilty plea will result in a mandatory driver's license suspension of at least 3 years up to your lifetime?
Yes.
Do you understand your felony conviction prevents you from owning or possessing a firearm?
Yes.
Do you understand that if a prison sentence is imposed on this case, when you get out, you will be placed on post-release control for at least 1 year up to 3 years under the parole authority?
Yes.
They will place conditions on you. If you violate the conditions, they could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes, I do.
If the violation is a new felony, then you could get an additional consecutive prison sentence for the violation. Do you understand that?
Yes.
If that were to occur, the maximum prison sentence for the violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes.
Do you understand that if a prison term is imposed, you are eligible for judicial release?
Yes.
You could be placed on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 60 months. Do you understand that?
Yes, I do, Your Honor.
Has anybody promised you I would be lenient on you just because you're pleading guilty today?
No, Your Honor.
Has anybody promised you what I will sentence you to in this case?
No.
Do you understand I do not have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Yes, I do, Your Honor.
Have you had enough time to talk with Ms. Tomaszek before pleading guilty today?
Yes.
Has she discussed everything about your case and answered all of your questions?
Yes.
Are you satisfied with the advice she has given you?
Yes.
Have you been threatened or coerced in any way to plead guilty today?
No, Your Honor.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes.
Do you have any questions?
No, Your Honor.
All right, Mr. Knopf, if this case went to trial, what would the evidence show?
Your Honor, had the case proceeded to trial, the state would have shown that on or about November 12th, 2025, in Menor, Lake County, Ohio, police responded to dealers at the Great Lakes Mall for the report of a theft offense. Officer Haddad discovered the defendant leaving the parking lot in a blue Jeep. Police activated their overhead lights. The defendant turned westbound on 84. Defendant then turned northbound on Plaza Street, running a red light. Then the defendant turned westbound on Menor Avenue before the police terminated the pursuit due to danger.
Ms. Tomaszek, anything to add to those facts?
Nothing on the facts, Your Honor.
Mr. Rivera, did you hear what Mr. Knopf said? The facts would show if the case went to a trial.
Yes.
Are those facts true?
Yes, Your Honor.
What is your plea to count one, failure to comply with an order or signal of a police officer, a felony? Is that 4?
It's
3.
Count 3, Your Honor.
Count 3, I'm sorry. Count 3, failure to comply, a felony 3.
Guilty, Your Honor.
Ms. Tomaszek?
Your Honor, reviewed the written plea of guilty with Mr. Rivera before coming in the courtroom. He's prepared to sign. Signature here, date here. Is
624.
got it. What's the date there? Your Honor, for the record, Mr. Rivera and myself have signed the written plea of guilty.
And Your Honor, for the record, I've witnessed the defendant and defense counsel sign the written plea of guilty, and now sign it myself with your permission to return to the bench.
Mr. Rivera, is this your signature on the written plea of guilty?
Yes, Your Honor.
Did you sign it voluntarily?
Yes, Your Honor.
Do you want me to accept your written plea of guilty?
Yes, Your Honor.
All right, I'll accept the written plea of guilty. Defendant was present with Ms. Tomasic, advised of all of his rights, made a knowing, intelligent, and voluntary waiver. He understands the nature of the charge, the consequence of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, and voluntary. Will accept the plea of guilty and find him guilty of count 3. Failure to comply of felony 3. I'll refer this for a pre-sentence report, drug and alcohol evaluation, victim impact statement. Sentencing will be July 30 at 2:30 p.m. and the bond is revoked. Anything else, Mr. Knopf?
No, Your Honor, thank you.
Ms. Tomasic?
No, Your Honor, thank you.
Good morning once again, everybody. It is TCF Live on a beautiful, beautiful Wednesday. And I say beautiful because I'm looking out my window here in the desert where it's going to be 111 degrees today. And there's a bunch of clouds. And clouds are good because I don't want sun right now. It's too much. Okie dokie, friends. Let's go to Michigan. We'll say good morning to Judge McNally.
The podium and tell me your name, please.
Hello?
Stay right there, Mr. Ward. Just stay right there. Keep mute and don't say anything, please. Your name? You're charged with driving while unlicensed or without a cycle endorsement, speeding. You have the right to an attorney. I'll be happy to provide you with one at public expense if you would like one. Would you like one?
Sir.
All right, so I'll go ahead and arraign you and then I'll send you to the prosecutor. Fair enough? On May 30 of 26 at 10 p.m., it is alleged that you did operate a motor vehicle in Allen near King and Woodhaven while you were unlicensed. That is a misdemeanor punishable by up to $500 in fines, 93 days jail costs, or all of those. Do you understand that? I can't hear you.
Correct.
And then you're also charged with speeding going 1 to 5 over. That would be a 1-point civil infraction. You understand that? Did you sign, read, and understand the advice of rights? Yes?
Yes, sir.
If you plead guilty, you'll be giving up all those rights. There will be no hearing or trial. Do you understand that? All right. You still wish to waive your right to a lawyer? You want a lawyer?
No.
You-
Sorry.
Okay, so you're going to represent yourself. Is that true?
Correct.
Not guilty, pleas entered. I'm going to enter a plea of denial on the civil infraction. I'm going to give you a $500 personal bond on the drive while unlicensed. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed. You go sit out in the hall. And we'll take the file to the prosecutor. And the prosecutor will call you out, okay? And then he'll call you and speak to you, and then either way, you're coming back in front of me. Okay?
Sounds good.
All right, you go right out there. Thank you.
Thank you.
Mr. Ward? Persifus, Delvendale, Gab, Ward, 26W843043. Your name again, sir? Where'd he go now?
He was just up on the video and now it's showing that he's back in the waiting room. Let me try bringing him in again.
Darrell Nicole Carter. 26W841067, 26W841163. Your name, ma'am? You're charged with violation of parental responsibility law. You're also charged with a second count, a violation of parental responsibility law. One was issued on or about February the 20th of 26. The next one was issued on or about March 31 of 26. Carter Glavon is the person that supposedly that was not required to go to school. You have the right to a lawyer if you want one. I'll be happy to provide you with one at public expense right now. Would you like a lawyer? So you're charged with violation of parental responsibility law. There's two different charges. And it is essentially that you failed to ensure the regular attendance of Carter Glavon. I'm not sure how old he is, but that is the charge. If you plead guilty or if you're found guilty, you could be sentenced to the following. These are just the maximums, up to 500 fines, 90 days jail, costs, or all those. Do you understand that, ma'am?
Yeah.
And you just sign, read, and understand an advice of rights form here today.
Yes.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. You understand that? You still wish to waive your right to a lawyer?
Actually, I was doing.
I'm sorry?
Yes, I do want.
I'm gonna enter not guilty plea. You posted bonds. Why didn't you show up here before?
I didn't even know that it was a workout for the school. Carter, it has offers.
Okay, so you should talk to your lawyer about that. I just asked why you didn't show up. I'm continuing. You had posted $300 on each of these after you missed a couple times. You cannot leave the state without the consent of the court or violate any law unless the hearing court is directed. You do have to ensure that your child attends school with no unexcused absences. I realize it's the summer now, okay? Give this to us. You go out in the hallway, they'll set you up, okay? Jeremy Allen Schultz, 23W830846. Mr. Schultz, you can come on up to the podium and tell me your name.
Jeremy Schultz.
You're charged with retail fraud. You have the right to a lawyer. Be happy to provide you with one at public expense. Would you like one?
No,
Going to represent yourself?
yes,
You got 4 other warrants out for your arrest. You don't do a very good job of showing up in court, sir. Judges don't like that. It is alleged you committed the offense of retail fraud in the city of Woodhaven, County of Wayne, at 21,000 West Road at the Lowe's store in the city of Woodhaven. That is a misdemeanor. It is punishable by up to $500 fines, 90 days jail under local ordinance costs for all of those. Do you understand that?
yes,
Did you sign, read, and understand the advice of rights?
yes, sir.
If you plead guilty, you'll be giving up all of those rights, and we're not going to have a hearing. We're not going to have a trial then. Do you understand that?
Yes, sir.
All right. Do you still wish to waive your right to a lawyer?
Yes,
I'm going to enter a not guilty plea for you. I'm going to set a bond. You posted a bond. Where you been?
I was incarcerated for the last 2 years.
Do you live on Chestnut still?
Yes, I do, with my mother.
All right. So, I'm entering a not guilty plea. I'm gonna let you go talk to the prosecutor. You cannot leave the state, so I'll continue your $300 bond. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed. You're not to enter or go near 21,000 West Road in Woodhaven or any other Lowe's. You're not to have any contact with employees of the Lowe's store, the Woodhaven Lowe's. You cannot write, phone, see, text, email them, or have anybody else do any of those things, except your lawyer can do that. No contact with prosecution witnesses. You're going to go out in the hallway. The prosecutor will call you in and you're all set. Any questions?
No, sir, thank you.
All right, good luck. All right. Do I have Mr. Ward out there? This is getting a little,
He keeps popping in and out, Judge. Like I bring him in, he goes back, he just popped in again. I'm gonna try bringing him in again. Like I spoke with him when he was first on here, so I know here he should be in there again right now. Mr. Ward, can you start your video, please?
Mr. Ward, I need you to tell me your name, please. You need to start your video. I hate to make you come here from Buffalo, but you got to learn how to get on here. I can't keep calling your name only to have you disappear. You have to start your video in the bottom left-hand corner of the screen, sir. Malat, Bradley Jacob Malat, 25W838481. Your name?
Brandon.
You got another retail fraud pending.
Or anything like that sort of thing.
I'm not going to dismiss this case. I'm just going to make a note that you're not compliant, have case pending in Southgate, 28th District Court for retail fraud. I will adjourn the review hearing pending the outcome of that case, okay?
Thanks, sir.
It is not to say that you're not going to have this conviction entered, even if you plead to something else. Do you understand that? Not going to cover it anymore. We'll adjourn we will adjourn this to a date. Give me a date at the end of July, will you please, Heather?
We could do July 22nd at 8:30.
At 8:30, okay? July 22nd at 8:30, that will be the new review hearing. All right? Any questions?
No, Your Honor.
All right, we'll see you back. You can go down the hall, get your notice. Mr. Ward, this is Delvendale, Gab, Persifus, Delvendale, Gab, Ward, 26W8430443. You have to unmute. All right, tell me your name.
My name is Ward.
I need your name again. You have to state your name again.
My fault. I said Ward.
Why the connection is so bad? Tell me your name again.
My name is Persifus Ward.
Okay, good. That was a good connection. Now listen to me very carefully. You're charged with littering from a motor vehicle. You have the right to a lawyer. If you want one, I'll give you one. You want a lawyer?
No. I just voted guilt. I did it, you know.
Go ahead and
admitted
arraign you,
to
and
it,
I'll send you to
you
the
know.
prosecutor. It is alleged that you did operate a motor vehicle on I-75 southbound near West and Woodhaven at 3:57 in the morning on May the 24th of 26. And they think you were littering. That is a misdemeanor, punishable by up to 500 fines, 90 days jail, costs, and all those. You understand that?
You said what?
You understand what I said? They think you were littering from a motor vehicle on that date. They think you threw a tissue out the window. They pulled you over. They charged you with littering. These are the possible penalties. I didn't say they were going to happen. It is punishable by up to 500 fines, 90 days jail, costs are all those. Do you understand that?
Yes, I can hear you now.
Did you understand what I said, sir?
90-day jail, and then you said I was
Do this like this. You're going to have to go
I'm trying to
somewhere
hear you.
else in the future. Listen to me very carefully. I can't do this. I'm not picking you up. You're not hearing me. I don't know where you're going to go. I don't need you to fly to Detroit, but I'm not going to have you in the same location because it's not working. Wherever you are, when we reschedule the court date, you're going to have to move to a different location. I don't care where it is. I don't know what to tell you, but I cannot pick you up. I cannot hear you. You cannot hear me. So I'm simply going to adjourn this, Heather. We'll adjourn this. We'll set a new arraignment pretrial date. And you're going to have to be in a different location and you're going to have to know how to show up. Do we understand one another? Of course we don't, because you can't hear me. Heather, chat with him. Give me a new date, please.
Okay, do you want to just do the Monday, July 13th at 1 o'clock?
Fine, July 13th at 1. Chat with him and tell him that, okay?
Okay.
He's gonna have to be in a different location, I think. I don't know where he is, but we can't pick him up. Thank you. Samantha Hite, Samantha Jean Hite, 26W841554. Come on up to the podium. Destiny Henry, you're gonna be next. Where'd you get districts on next 5 then?
Yeah, it's up.
Huh?
It's up there.
Your name, ma'am? You're charged with the violation of criminal responsibility law. You have the right to a lawyer. Would you like one?
Yeah.
On May 29 or 26, they think that you did the offense of retail fraud by failing to ensure the regular attendance of your child, Emmett Hite at Woodhaven Upper Elementary School at 24825 Hall Road in Woodhaven. That is a misdemeanor punishable by up to 500 fines, 90 days jail, costs are all those. Do you understand that? Yes?
Yes.
Did you sign, read, and understand the advice of rights form?
Yes, that's fine.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that? You still wish to waive your right to a lawyer. I'm entering a not guilty plea, $500 personal bond. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed. You're to ensure the regular attendance of your child. I realize this is summer.
Yes, sir.
Maybe the child isn't in school now, but if this somehow pushes out, you're to make sure that child attends school. You understand that?
Yes, sir.
All right, any questions? All right, good luck. You're gonna take that file to the prosecutor. Say the enemy, Mr. Zone.
Who, Hite's going to prosecutor?
Yes, she's representing herself.
Just have a seat in the hall.
Did we ever get that,
No.
okay. Still waiting the blood results, Mr.
They're in there, Judge.
They are?
Yeah, they told me they were in there. And apparently they were in there. I'm sorry to speak with Judge.
Let me see. Are they in the pre-sentence report?
Might be there too, Judge. But it was in the file. They found it after I left here that Sunday.
Oh, they did? People against Purnell, Lamar, Fountain, 26B150239A and C. Let me check. I ran.
I didn't bring my reading glasses to you, so
That's all right. I ran through this real quick this morning. I didn't see them in here, but let me find them.
I know that after I left here, they probably said in the file, come back, but he was on his way back to Toledo, and he's on Zoom this morning, Your Honor.
Okay, sir, your name?
Purnell Fountain.
Judge Edward Zelmack for the defendant. I appreciate you allowing me to have him appear by Zoom at the last moment. He's from Toledo. We've had 2 false starts on sentence, and he has a family emergency this morning.
That's fine.
I think, Mr. Fountain, what was your blood alcohol level, Mr. Fountain?
I believe it was like a 0.14, I believe.
It was a blood draw, Judge.
All it says is that in the complaints, and they didn't do.
It drew blood.
I know, but as of April the 23rd, the Brownstown Police Department still didn't have them. They were still pending. So then we took the plea on the 22nd. Sadie, go see if she said she'll that. So I had her get a hold of them this morning. I don't want to make a bigger deal of this than it is, but I still want to know for sure what, it sounds like that was the PBT result. So let me just double check and make sure we have them. She said she was going to send them. Oh, you're fine. Stay right there. Let me see. I think that she should be
Miss
coming
Foley's
back.
not here today because she remembers too, because she called me as I got in the car, but it was too late.
Who's here for Brownstown today?
Miss Foley's here, she would know because.
Oh, she's here?
Why, I don't know. She's always here.
Yeah, I thought you said she
Do you
was.
want me to call the conference room and see if she's in there, Judge?
Yeah, and ask her to come in here.
Okay.
I don't have them either, but I saw the results because they called me when he was charged and she sent him a correspondence.
Okay. All right.
I know it wasn't that high.
Well,
I mean, that is high, I'm sorry, but when I started.
No, but I get it.
15 was something.
I get it. Here they are. So I don't need her. He had THC in his blood. I don't even see where they have a. Oh, call in the prosecutor, will you?
She's on her way over to you right now, Judge. I got a hold of her.
Thank you. All right, so let's just wait for her and we'll go from there. They didn't send me any report other than saying he had THC in his system.
Shall I have a seat, Judge?
No, you're good. Just wait right there if you would. It won't take. Miss Foley Carter, your name?
Caitlin Fuller, Carter, Rossman Township.
I took her to drive a plea to operating while impaired. It was due to the consumption of alcohol. I've been trying to get the blood results from Brownstown. They sent the packet over. I only see where he had THC in his system.
Your Honor, it looks like he had alcohol of 0.149 grams.
Is that? Well, all they sent was the supplemental reports. This report was completed, it looks like, on April 13th. So I don't have an original report regarding alcohol. Do you have that?
Your Honor, I did also send it over to the court after this was adjourned.
Okay. All right, good enough. So, yeah, if you could just give me a copy for the file, that's fine. All right, Mr. Fountain, I'm sorry about the confusion here. State your name again, please.
Purnell Fountain.
Mr. Zelnick, have you reviewed this report with him, and are there any material additions, corrections, or deletions?
None at all, Your Honor.
And for the record, she's handing me this report. It does say 0149. So go ahead. I'm sorry.
I'm delighted that my client has a better memory than I do.
Right.
And Your Honor, I see nothing, this is a true first offense. I see nothing else to add. He's in Ohio and he said he's prepared to come once his mother squared off, perhaps tomorrow, to pay the fines and costs and full and arrange with probation if you would allow him to come meet with probation tomorrow. Is that correct, Mr. Fountain?
Yes.
That's assuming you don't incarcerate him.
No, I got it. I got it.
So he'll be here tomorrow to complete the matter in the court recalls. He was here twice. Once I was out of town, once we couldn't find the blood results. So I apologize.
How
This
far?
time he couldn't make it.
How far is Holland from here? Is it outside of Toledo?
Yes, sir.
So it's about an hour, is that right?
Little over an hour, about hour 7, hour and 10 minutes.
All right, good enough. Is there anything you would like to say, sir? You're all set.
Thank you, Your Honor.
Thank you.
No,
Anything
sir.
you- All right, I'm gonna place you on probation. I'll adopt this report, 12 months. You can leave the state, can leave state without consent. You live in Ohio. You cannot violate any law or ordinance if you change your address, place of employment or home telephone number. You do have to notify probation. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume one of those. You're to submit to chemical testing, PBTs and ETGs monthly or more on demand of probation. Kratom poppy seeds and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. I do want you to attend the Victims Impact Panel. I do want you to attend the Substances Abuse Group through Class A Training Center. I'm not going to make you come here for the court work program. I'm going to let you do 4 days jail credit, 1 serve 3, and I'll let you do those by way of community service. And I'm going to give you until August the 15th to complete 24 hours of community service. You can do that at any nonprofit organization of your choosing, okay?
Yes, sir.
Fines are $300, cost $200, 75 victims' rights fee, $50 justice assessment, 6 1/4, screening fee 60 for 685. Probation fees are $240 for a total of $925, and you have cost of recovery of $218 for a total of $1,143. If you violate, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal. You have 14 days to apply for a court-appointed lawyer for purposes of appeal. You may be eligible for early discharge. You get everything done, no violations within the preceding 90 days by statute. You are entitled to early discharge. So you can make a petition after 6 months. So sometime around Christmas, okay?
Yes, sir.
All right, so I think I'm gonna just say pay by tomorrow. Is that you can pay in full by tomorrow? Is that what he said?
You can pay that by tomorrow in full, is that correct?
I don't know if I'll be able to pay it in full, but I will be able to get a big chunk of that taken care of tomorrow. But I know for sure I'll have it all the way paid next Friday when I get my check. Absolutely.
You know, Steve, what's the big?
Listen, I'm just gonna give you until a week from Monday to pay it in full. You gonna be able to do that?
Yes, sir.
So I'll make that, let's see, and that will be on the, what day is that? July 6th. You just pay in full by July 6th. You better check over there. I don't know if, I'm sure they've got people that are gonna be there tomorrow. But I want to make sure he's not sitting around either. On the defective equipment, fines and costs are $120. Okay, so $120 on that. And I'll say pay that by July 6th. If you need more time, no problem. Call the court. We'll go on Zoom. I'll give you an extension. Okay?
Yes, sir.
All right. I wish you well. Thank you, Mr.
Thank you,
Zellman.
Mr. Fountain.
Thank you.
Like with your mother today, please bring a big chunk when you come here tomorrow. I'll check with probation.
All right. Have a good day.
Thanks a lot.
Good morning once again, everybody. It is TCF Live on a beautiful Wednesday. Still a little cloudy here, which I'm liking. Helps keep the heat down. It'll only be like 127 today instead of 137. Okie dokie. We'll keep an eye on Judge McNally. Might go back there, but let's go back to Judge O'Donnell, new contestant.
We're here on 25 CR 1466, Jason Cole. I sentenced you on March 26. One of the terms of probation was 180 days in jail, credit for 490 suspended, 86 to be served, starting today at 10 a.m. Scheduled this review hearing, so tell me what's been going on since you were here last time.
Yes, Sharon. I have been going to AA 7 days a week and attended therapy weekly, and then also been going to marriage counseling with Ashley. I moved back into the house in early April, and life's going a lot better. Our home life is good. We're working to rebuild, spending a lot of quality time with my son and Ashley. I've gotten my life back on track. Got my 8-month sobriety coin a couple weeks ago. Have my next one coming up soon. My entire life's changed in the past 8.5 months, but the last 3 been a much more present father and husband, and I'm actually enjoying being a father and husband. We went to the Science Center on Father's Day, and at how my son looks at me now and how he reacts to seeing me is completely different than they used to be. How he and Ashley talk and communicate and just discuss things, even if we disagree, has completely changed. My entire life has changed in the last 9 months, Your Honor.
What are you doing work-wise now?
I'm consulting with HR Methods still, and have been for the last 3 months, so it's commission-based. So I've went to 4 events, have a few clients, but been interviewing for a non-consulting job. I've applied to 127 jobs. I've got a offer for Aerofluid products, but I also have another offer that's being verbally extended today at 11 and then 2 more companies on final interview or the offer stage as well, Your Honor.
All right. Do you, your counseling, is that through the VA?
Yes, Your Honor.
What do you do? Tell me what it is.
So my therapy through the VA is EMDR therapy. So it's actually going back and not only discussing the traumatic situations in Iraq and also coming home, but also finding healthy ways to cope with them. So not just talking about the situations that have happened, but also trying to change the narrative in a way. You talk through the experience and you do finger taps and stuff like that and try and figure out a way to shift the narrative in your head to where it's not traumatic. When I first started, I can't say it was very helpful.
When did you first start it?
Almost 9 months ago. Now I was talking to a few former coworkers about a week or 2 ago, and it was the first time they had ever heard that I had deployed. I'd worked for them with them for 3.5 years, working a couple hours a day with them, and they never knew that I had deployed. They didn't know hardly anything about the military, and it's shocking the change of I can talk about the military in a constructive way, and I don't shut out that part of my life. And truthfully, I think that has a lot to do with this therapy, but probably more to do with the sobriety.
How long do you anticipate therapy continuing? Do you know at this point?
At this point, indefinitely. It's working, just like AA. Truthfully, it's working, and I don't want to mess with a good thing. I'm sober, I'm in a good place, therapy's going very well. If my therapist makes a recommendation to reduce the interval or slow down, I'd follow his recommendation, but if it's not working, we'd go back to the previous. So I'd be very cautious to slow down at all.
All right, so how often are you going to the AA meetings?
7 days or 7 times a week. Sometimes I double up days. I think historically I've went anywhere from 5 to 7 days a week. Over the last 3 months I've went 7 days or 7 times per week, but normally about 5 days. It's very good. When I first got into AA, they said sobriety is the most important part of my life, or the most important thing in my life. I said, that's ridiculous. You know, you got family, you got job, you got all this stuff. And, you know, over the last 9 months, I've realized what they meant. Without your sobriety, you don't have anything. And even if you do, you probably don't have it long term. I'm very committed to my sobriety.
Do you go to the same meetings, or do you go to different places? What do you do?
I go to the Arid Club in Eastlake, and then also the Night and Day Club in Willoughby. So sometimes I'll go to different meetings. I normally pretty consistently go to the same meetings, but I attend those 2 sobriety clubs the most. And then I still drive to Strongsville once a week with my sponsor, Steve. He's here today. And actually go to my home group meeting that's in Strongsville.
What observations have you made about some of the other folks at the AA meetings?
I would say there's a varying level of commitment, but the people that actually put in their all, their lives have changed. You know, when I first got there, it's funny. I walked in and I was in, you know, not a good place mentally, and everybody's laughing and joking and smiling, and you know, it was completely different than what the movies portrayed as. And over the last 9 months, I've gotten to know people a lot better. And some of the people I look up to the most have had exceptionally turbulent pasts. And I've realized how much they've changed their life and didn't let their past adversity define them, but never forgot it. And that's why I'm going to remain committed to AA. Truthfully, I'm sober. I have no intention of ever drinking again. But I know if I go to AA, I can make sure I never drink again.
All right, Ms. Warren, anything you want to add?
Your Honor, he's been compliant with probation. He reports as when he needs to. If your entries of the negative, supervised verification of all services that the court requires. There's been no issues on probation.
How do you find her to be?
Great. Very, very helpful. And very attentive to not only compliance with the court, but also making sure that home life is good too.
Okay. Mr. Brown, anything you want to say?
I don't know that there's much more I can say. Judge, it appears he's in full compliance. Night and day between where he was back in October of last year. Judge, I'm asking the court to continue him on community control, allow him to continue the path towards progress and success that he's on.
All right, I will vacate the 86-day sentence. It was to begin at 10 o'clock this morning, and you're continued along the same terms of community control, and keep doing what you're doing, because if it's working, obviously you know to keep on doing it. So.
Yes, Your Honor.
All right, good luck.
Thank you, Judge. All right.
So Michael says in the chat, this is a nice story. I agree, and let's be real. We don't see a whole ton of quote-unquote nice stories out of Judge O'Donnell's court. Usually the defendants are a lot more problematic, and they are on a bad track. This guy seems to be on a good track, so prayers for him that he keeps it going, quite honestly. Good morning once again, everybody. It is TCF Live in Hour 1. We have some new friends out there this morning. Good morning to you. You've stumbled into one of the best communities on YouTube, and I don't say that just because I run it. There are good people here. If you haven't already, consider subscribing. If you're not already, consider becoming a channel member. $2.99 a month. Not a lot. Goes a long way to help the channel, though, and you get access to a whole bunch of things, including access to the pre-show, which is a lot of fun. Okie dokie. Let's go to Florida, Judge Wade Mercer.
Mr. Lewis, good morning. You're here for first appearance accused of one count of battery, misdemeanor battery. There is probable cause for the charge. Mr. Lewis, I remember first appearing you recently, so I went and looked at that case, and it looks like that case was dismissed by the state within the last couple of weeks. So that case is no longer pending against you, so that's good news. So I think you're entitled to a bond as far as I can tell. Let me listen to the attorneys, and I'll address that bond status. Mr. McDaniel, anything on behalf of Mr. Lewis?
No, Your Honor.
Mr. Mitchell?
No, Your Honor.
Mr. Lewis, I'm going to set your bond at $3,500 cash or surety. You have a condition of no contact with the alleged victim at all, Mr. Lewis. You'll get a chance to use the phone in a few minutes to post the bond. Just have no contact with your father. If you post the bond, you'll be released. If you don't post the bond, we'll see you on an upcoming court date. Mr. Lewis, the jail will give you a notice for your court date before you leave the jail, and that notice will be for July 27th will be your court date. They'll put that notice in your hand. You will not get a copy in the mail. What they'll give you will be the only notice you get. Mr. Lewis, you'll get to use the phone shortly. Do you have any questions, sir?
No, sir.
Wish you the best, Mr. Lewis.
Mr. Lewis.
Kenneth Collier. Mr. Collier, good morning. You're here because you've been accused of one count of battery also. I've read the complaint in your case. There is probable cause. I've also looked at your criminal history, which is only one prior charge that showed up. That was a misdemeanor offense. So your criminal history is not bad at all. That was in the state of Kentucky. It does not show a disposition on that charge. Mr. Collier, you and the alleged victim were residing together before this incident happened yesterday, correct?
Yes, sir.
Okay. Do you have somewhere else you could live on a temporary basis?
I have a camper on the 5-acre lot. I had been staying in when argument pursued, I can go back there, or I don't have a place, no.
Is the camper, you say the 5-acre lot, is that where she's at as far as you know?
No, she's in the house, sir.
I know that, I'm sorry, is she on the 5-acre lot? Let me be clear.
Yes, it would be, yes.
How far is the camper from the home?
Acre and a half away.
An acre and a half is an area. It's not a distance, it's an area. How far? 100 feet, 500 feet?
500 feet, 200 feet, around there.
That's a big difference. That's a big difference between 500 and 200. What about, does it have electricity in the camper?
Yes, sir. It's fully hooked up.
Mr. Mitchell, what's your thoughts? Let me ask one more question. I'm assuming it shares a common driveway. Is that true?
We have 2 driveways, sir.
The camper has a separate driveway than the...
It has a driveway that circles around and goes out another driveway if you want to go that way. So there can be 2 separate driveways, yes.
Does one of them go by the house and one of them not go by the house, or neither one of them goes by the house?
They can both go by the house.
Thank you. It's kind of a circle driveway. Makes sense.
Yes,
Mr. Mitchell?
but I wouldn't have to drive all the way around.
Okay. Mr. Mitchell?
I would say, if anything, no contact with the victim and stay 100 feet away from the house in that situation.
That may be a good option. That may be a good option. Is it, if I give you a conditional release and let you stay in that camper, is it possible for you to live there and not go within 100 feet of your home?
Yes, sir.
Now, if she's lawfully removed or she leaves voluntarily, that changes things. You can go there, but you can have no contact with her or 100 feet of your home as long as she's living there. Mr. McDaniel, anything you want to add?
No, Your Honor.
So, Mr. Collier, given your history, I'm going to let you pick between a bond and a conditional release. If you want to post a bond, it's $2,500. I am going to offer you a conditional release. Either way, you're going to have a condition of no contact with the alleged victim and not go within 100 feet of the home she resides in, Mr. Collier. And we'll also give you a notice for your court date. That'll be
27th.
July 27th at 9 a.m. Mr. Collier, do you have any questions?
No, sir.
There's no allegation of alcohol being involved in this, was there?
Let's see. Let me check again.
It's a standard on release anyway. Yeah, Mr. Gibson's right.
Ronnie, you accept
All right, so I'm going to grant you the conditional release. What's going to happen next is the jail's going to give you that notice for your court date. Then they're going to let you come to the courthouse. They're going to bring you up here, actually, because that's where the conditional releases office is at. Mr. Collier, when you get here, you'll meet with one of the conditional release officers. They'll go over the release with you. They'll give you a chance to ask questions. They'll give you the rules in writing, and then you'll be free to go. Mr. Collier, just make sure you stay away from her. I don't want any problems. As Mr. McDaniel's probably explained to you already, you can contact law enforcement one time for assistance to go in the home and get your belongings. They'll have to accompany you in the home, get your clothing, things you need for work, so you can take it to the camper. That's the only time you can go in that home. You just got to stay away from there unless law enforcement's with you that one time. Mr. Collier, do you have any questions?
No, sir.
You will get to use the phone before you leave the jail, and we will see you at the courthouse in just a few minutes. The reason for using the phone is to set up transportation to pick you up. You can tell your friends or family you can be picked up at the courthouse in probably a half hour, maybe 45 minutes, okay?
Yes, sir.
Have a good day.
Thank you.
Yes, sir. We have Zoe Morris next. Ms. Morris, good morning. Ms. Morris, you're here because you've been accused of violating the terms of your state probation or community control. I've got a copy of the warrant in front of me. It has a no bond warrant signed by Judge Garcia. So, Ms. Morris, what I'm going to do is arraign you this morning. What that means is if you want a lawyer appointed, I'm going to get you one appointed today so they can start working on your case. Would you like to have an attorney appointed to represent you, ma'am?
Yes, sir.
I'm appointing the Public Defender's Office of the 14th Circuit to represent you. Listen to Mr. McDaniel. I'll see if you have any questions in just a minute.
Your Honor, we're going to have to not guilty. Yes, to set this on July 9th court docket, and I advise that an attorney will come by and speak to her prior to that hearing.
July 9th. Mr. Mitchell, anything?
No, Your Honor.
So your attorney will see you before your court date. Do you have any questions, Ms. Morris?
No, Your Honor.
Have a good day, ma'am. We have Melody Martinez next. Ms. Martinez, good morning, ma'am. You're here for first appearance, accused of one count of failure to return leased property valued at more than $300. Ms. Martinez, there is probable cause in the complaint. Your criminal history is not bad. I think I saw one charge from 2018 that was dismissed. And that may have been it. Were you arrested somewhere else on this warrant, ma'am?
No, that Calhoun County just picked me up on the warrant, last Monday.
So you were arrested in Calhoun County. Yeah, I'm just trying to figure out, have you been in jail? Did it take you some time to get here?
Monday
Yeah.
before, so it's been 9 days now, 10 days.
Oh, wow. Okay.
Actually,
Okay.
about cannot
Go
go
ahead.
So that's why I was just gonna ask, I didn't know if the court had any kind of other release options, but she's, you know, she said in Calhoun County, I think they thought that she would post the bond, but she has not been able to.
Yeah, well, if I had written down here's what I wrote down. My notes say possible conditional release, but no job ? So the paperwork I've got says no job. So is that accurate, ma'am?
Do what now?
Do you have a job?
Do you have a job?
No, I was in a car accident in January and
Okay.
I'm going through medical stuff about my back.
So were you employed before the accident?
I was doing Spark delivery for Walmart.
Okay. So you've had no bond for 9 days, though. Is that correct?
Correct.
Why would it take
Well, I
9
had a
days to
bond.
get her from Calhoun County? Did you have local charges down there?
No, I didn't have nothing.
This takes us, you know, a lot of times our sheriff's office looks at the bond when there's a bond set and they kind of, you know, both sheriff's offices assume someone will make it, you know, so they don't want to drive all the way down there to go pick them up and they're bonding out at the same time. So
This was an old case that I put a bond on when I signed the warrant because I don't particularly like those. The rental center place held this thing for months before contacting the sheriff's department. So I'm leaning towards a release, Mr. Mitchell. What's the state's input?
Given her lack of history, no objection to that.
Mr. McDaniel, anything else?
nothing else, Sean.
So I'm going to let you pick between the bond that was set, but I am going to offer you a conditional release in light of all the factors I've heard this morning. If you want to accept the conditional release, you'll have the standard conditions of every release, plus you'll have a condition to have no contact with that rental center place that you allegedly got this item from. Do you understand your choice between the bond and the release, ma'am?
Yes, sir.
You prefer the bond or the conditional release?
Conditional release.
Thank you. We'll grant you that. The same thing I told the last person, Miss Morris, actually, it wasn't Miss Morris. It was, who was that that got a conditional release?
Collier.
Mr. Collier. It's true that the jail will bring you to the courthouse in a little while, ma'am, probably 30, 45 minutes. You'll get to use the phone before you leave the jail. The jail will also give you a notice for your court date. Your court date will be a felony date, and that will be when?
I think we're still 7th. What's the cutoff for that date?
July 7th. July 7th. Does that sound right?
Yeah.
Yes, sir.
July 7th at 8:30 a.m. will be your court date, Miss Martinez. They'll give you that notice before you leave the jail. Miss Martinez, you'll get to use the phone in a few minutes for transportation purposes. Do you have any questions?
No, sir.
All right, ma'am. Have a good day. The next case I have is Timothy Parrish. Mr. Parrish, good morning. Mr. Parrish, you have a hold out of Bay County. It looks like you're accused of one count of insurance fraud down there. There's no bond on the warrant. Mr. Parrish, I tried to find the warrant and there's no bond on it. I did find it this morning. So what that means is you're going to be picked up by Bay County. When you get to Bay County, that judge down there will decide if you're entitled to a bond or not. You may or may not get a bond. Most of the time you get a bond unless you're on probation or have a charge pending. You're already on some type of pretrial release. So the judge down there will make that decision. But right now there's no bond on this warrant. Mr. Parrish, do you have any questions?
No, sir.
All right, sir. I wish you the best. Joshua Wilkins.
Yes, sir. Good morning, Judge.
Good morning, Mr. Wilkins. You're here because you've been accused of one count of felony retail theft in case 26-338 CF. Mr. Wilkins, there is probable cause.
Yes, sir.
I've also looked at your criminal history, which does show several prior charges, one prior prison sentence, I believe. I think you're entitled to. Let me finish. I think you're entitled to a bond because it looks to me like you're not on probation now and you have no charges pending. Is that correct?
Yes, sir. Also, I paid over $15,000 with fines and everything like that, and applied with the Office of Executive Clemency on the Esplanade Way and got my rights back and everything.
Okay, great. Right.
Yes, sir. So I mean, I really would like the chance at any way, or like if y'all were offering conditional release. I do work hard every single day. I can pay everything back. I'm not, you know, I apologize for being right here in front of you today.
Well, it's you're not going to get a conditional release with your criminal history and the number of thefts you have on your record, but you're certainly going to get a reasonable bond, maybe even a misdemeanor bond, maybe where I land. But let me listen to the attorneys before I make that decision. Mr. McDaniel, anything on behalf of Mr. Wilkins?
No, Your Honor.
Mr. Mitchell?
Just a moment, Your Honor. We're not opposed to a misdemeanor bond if you want to give them that.
Thank you. So, Mr. Wilkins, the amount you allegedly stole was less than $30 item. So based upon that, your history is what I've already mentioned. It's not good. But I'm going to set you what would normally be a misdemeanor bond. It's $2,500 cash or surety. If you go through a bond, that means it costs you $250 to get out of jail. Is there a request for a cash bond, Mr. McDaniel?
Like I don't.
Cash bond, Your Honor.
Mr. Mitchell, any objection?
No objection.
$250 cash bond in that event. That way you don't have to worry about going through bonds. When you post the $250, you'll be released. The jail will also give you a notice for your court date, Mr. Wilkins. That should be the June court date for felony court. July 7th. I'm sorry, July 7th will be your court date. They'll give you that notice before you leave the jail. Now, when we give somebody a written notice, they do not get a notice in the mail. So make sure you keep up with that notice they're going to give you. That'll be your court date. Do you have any questions, sir?
Yes, sir. Otherwise, if I'm not bonded out, which or whatever, so then I'll be sitting here until July 7th.
Yes, sir. If you don't post bond, you'll sit there until that day, but you may come up instead of the morning, you may come up in the afternoon. Mr. Mitchell, help me out here. Are jail cases a different time of day?
Jail cases are in the morning at 8:30. For arraignments, they all kind of take place at 8:30.
So you have the same court date though, right?
Yes.
Same court date either way, whether you post bond or not. Okay.
Okay.
Have a good day.
Thank you.
Yes, sir. We have Andres Mathe.
Yes, sir.
I don't think I put no contact on Mr. Wilkins. Mr. McDaniel, we need to make sure Mr. Wilkins knows there's a condition of no contact with that store where this allegedly took place at. And I did $2,500.
$250.
I did. Thank you. I did $250 cash bond. And sir, is your last name Math or Mathe?
Mate.
Mate. Mr. Mate, you're here because you've been charged with 2 counts of indecent exposure and 2 counts of breach of the peace. There is probable cause for the charges. I think you're entitled to bond as far as I can tell. I'm going to listen to the attorneys and then I'm going to set your bond. Mr. McDaniel.
Nothing, Your Honor.
I need an interpreter because don't.
What do you say?
He said he needed an interpreter.
Your Honor, I'm just going to ask the court maybe to bring him back tomorrow with a Spanish interpreter. He's having problems understanding what the court was saying. Okay. I talked to him before and we will try to get through it, but I think he would feel more comfortable with a Spanish interpreter.
Okay. So is Spanish your first language? Is Spanish your first language or do you want a different type of interpreter?
It's supposed to be Romano, it's okay. It's no Spanish.
Romanian is his first language, but he speaks fluent Spanish.
Okay. So Spanish interpreter be okay?
Yes, sir.
Okay. So, Corporal, if we can do an interpreter request, please, for the jail. I'm going to go ahead and set a bond this morning in the event you're able to communicate with him or you have someone out there that speaks Spanish. Mr. Mitchell, anything on the bond?
No, Your Honor.
For today's purposes, his bond's going to be $3,500 each on 4 counts, 4 misdemeanor charges. That's a total of $14,000 bond. So if he can post the bond and you're able to communicate that to him, Corporal, then he'll be released and we'll give him a notice for his next court date, which will be the
27th.
July 27th at 9 a.m. If he doesn't post a bond, Corporal, we need the jail to do an interpreter request for Spanish interpreter, and we'll go through this again in the morning. And that bond may or may not be modified in the morning, but right now that'll be the bond.
Yes, sir.
Mr. Mate, I'll see you in the morning, okay?
Okay, sir.
Okay. Have a good day.
35 times math is not math and 14,000? Is that what that is? Okay.
35 times 4, yeah.
I'm an attorney. I don't know math.
The bond does have a condition, no contact with either of those gas stations. So Corporal, make sure that he's made aware of that if you do find someone to speak Spanish at the jail. One was a Love's truck stop. I can't remember what the other one was.
It's the one in Cottondale. It's the McDonald's that's right next to it too.
These were two gas stations across the road from each other. I don't think it was Cottondale, was it? This wasn't a Cottondale case.
It was Cotton.
So it was a Love's and a Sun Stop.
Sun
No
Stop,
contact with,
right down the street, across from.
no contact with, okay, no contact with Love's or Sun Stop. Love's or Sun Stop. Cottondale has a Sun Stop?
Yeah, right across the street from it.
My wife has a discount card there, saves $0.05 a gallon. Mr. McDaniel, it's everything I had on my list. Anything else from the jail this morning?
Nothing else, John.
I'm sorry, I said from the jail. I meant the PD's office. Corporal, anything from the jail?
No, Your Honor.
And Mr. Mitchell from the state?
Nothing from the state, Your Honor.
So hang on just a second, gentlemen. I got one thing to tell you about on a warrant request I had.
Well, we're not going to hear about that warrant request, I guess. Good morning once again, everybody. Now entering hour 2 of TCF Live. Good to have you all here with me this morning. It looks like rain outside here, which means it's most definitely not going to rain. And that makes me sad. Oh, well. Let's do this. Let's go back to Michigan, back to Judge McNally for a while.
You want to go over to victims?
Pardon me?
You want to go over to victims?
Not yet.
Okay.
Your name? All right, you were in front of me and I ordered you not to have any contact with the victim as part of your bond conditions that I entered on May the 27th. And I have here in front of me a charge that alleges that you failed to refrain from having contact, direct or indirect, with Michelle Newsom. If I find you didn't have contact, you'll be exonerated. If I find you did have contact, that is, you either called her, wrote her, saw her, texted her, emailed her, phoned her, I don't care what, any one of those scenarios, then you could have your bond could be forfeited, the relief revoked, and a new bond set. Do you understand that? Do you have a lawyer representing you on this case?
Carmen. He's on.
Did you speak to Mr. Carmen today? My apologies.
He is out there.
I'm gonna need him in here. Why don't you have a seat at the table right behind you? Sean Eric McKenzie. 25F2433230. Your name?
John McKenzie.
Why'd you wait so long to take care of this?
To be totally honest, I don't know what this is leading for. I'm here for another matter.
You got a ticket for impeding traffic back in January of 25. It was out of flat. They think you were operating on West Huron River Drive.
Yeah.
Hang on. Went into default. We show caused you. Didn't show up for that. Back in May of 25, I issued a bench warrant, May the 20th, 25. Then it looks like you came in here on May the 20th of 26. We canceled the warrant and you must have posted the bond. Is that what happened?
Yes, sir.
Why didn't you show up on this? Don't tell me you forgot. Everybody forgets. Why didn't you show up?
I tend to avoid situations like this, because I have to call off work and my work isn't, exactly understanding.
That's a reason. It's not a good reason,
I understand.
but it is a reason. Not one I'm gonna buy. Okay? Heather, does he still owe $237?
272 is his balance.
You have another 35 with you?
Okay.
Good. Trying to pay. $265 total. Balance is waived. I trust that I jumped the gun here a little bit. I trust that the bond is in his name, right?
Let me take a look. Yes, it is. He
So
has
you
a
go
bond
down-
of 237.
Good. You add another 28 on your credit card, and that'll take care of it. Good luck. Have a good day. Go down and deal with them. Stop doing that. It's not a good idea. Thank you. Destiny Henry. Danye Henry, sorry. 26W8424995. Come on up again, ma'am, and state your name. I didn't realize you had a lawyer already, Mr. Carmen.
Michael A. Carmen, because created before, I put the pen ground.
So I just explained the charge to her. My apologies. I didn't realize you were on this. For failure to refrain from having contact, direct or indirect, with Michelle Newsom. And, ma'am, and I did explain to her that if I find she had contact, I could revoke her release, forfeit her bond, and set a high cash bond. And that is the charge. And I'm asking you at this point, how does she wish to proceed? Does she want a hearing or does she wish to plead guilty?
She's gonna plead not guilty and we're asked for a hearing, which should be very quick and simple.
Okay. Let's call in the Woodhaven prosecutor and let's get the victim in here. And you can have a seat right behind you, man. Is Albaraki yours? Which ones do you have? You got Mr. Patrick, right?
Yes, I have that. One person is here. Who's mine? Hello.
All right.
Who?
Jeremy Allen Schultz, 23W8300846. Your name?
Jeremy Allen Schultz.
All right, so you just met with prosecutor and you are going to plead guilty to attempted retail fraud, correct?
Yes, sir.
So it says older case, defendant since charged has numerous multiple jail sentences.
Yes, Your Honor.
Your appearance?
William York on behalf of the people of the city of Woodhaven. I discussed this matter at some length with Mr. Schultz. He has served jail sentences in Eaton County, Macomb County, Oakland County. He suggests, although I wasn't able to confirm myself, that he did attempt some pleas by mail over the course of time. He has retained Jeffrey Puda for other matters. He came to this court indicating he wished to represent himself. And so the people felt that the ends of justice would be met by an attempt to plea.
And that's fine. I wasn't actually calling you in on this one.
Oh.
But you said, and you don't have any objection to a suspended sentence.
Affirmative.
You didn't agree to that.
No objection to a suspended sentence, but it's not a killaboo plea, if you will.
It just, you're just telling me I don't have any objection if the court just imposes fines and costs.
Affirmative.
But there's no sentence agreement between you.
No.
So do you understand I can go along with that, but I don't have to go along with that?
Yes, sir.
And you understand that this is punishable by up to $250 in fines, 45 days jail, costs are all those?
Yes, sir.
And did you sign, read, and understand the advice of rights?
Yes, sir.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that? You still have the right to a lawyer. If you want to change your mind, I'll be happy to provide you with one at public expense. Do you
No, sir.
understand that? You still wish to waive your right to a lawyer?
Yes, sir.
Anybody force you to do that?
No.
The charge attempted retail fraud, how do you plead?
Guilty.
On May 17 to 23 at 8:29 a.m., were you at Lowe's at 21,000 West Road in the city of Woodhaven?
Yes, I was.
And did you take out some kind of a mower, ego mower, it says, while in the store and walk past the register without paying for it?
Yes, I did.
And was that valued at $649?
Yes, sir.
Anybody force you to plead guilty?
No.
Are you on probation or parole?
Yes, I am on probation.
Were you on probation on May 17 of 23?
No, I was not.
All right. I'm gonna accept your plea to attempt retail fraud, dismiss the retail fraud. I'm going to still order a pre-sentence report. I want to get everything, I want to know a little bit more about this. Pre-sentence report, sentence date. I already told you the bond conditions. We'll give them a sentence date. Heather,
We can do this one on, how about July 22nd at 8:30?
July 22nd at 8:30, okay? So you're gonna go down the hall, they're gonna give you your paper notice, then you're going to go over to probation where you'll be interviewed. Any questions?
No, sir.
Okay, good luck to you. Thank you. Now, this is the one I was actually calling you in on. Destiny Danier Henry, 26W842495. I'd like the victim in here. I have arraigned, Mr. Carmen, your name again?
Michael A. Carmen, P7384, that's the defendant, Your Honor.
Ma'am, your name?
Yes, ma'am.
And, ma'am, your name and your appearances?
Jessica Gordon on behalf of probation.
William York, I may have the people with him.
So Mr. Carmen has advised me that his client wishes to have a hearing. So I'm going to go ahead and swear in the victim as well as Ms. O'Donnell. And we'll go from there. Both of you raise your right hands, please. Do solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole true self you got. Ms. O'Donnell?
Yes, sir.
Ms. Newsom? All right. John, why don't you take that garbage can over there for her, please? I'm gonna ask you to throw your gum in there, please. All right. I don't care how we start. You can go ahead and start.
I have one bond violation I issued on June 22nd. My one bond violation is failed to refrain from having any contact, direct or indirect with Michelle Newsom. I was contacted not only by the victim, but by the detective on the case for Woodhaven PD regarding that Destiny, Miss Henry, had contacted the victim via text message. The text message is from an iCloud account that I do have, that I do know is Miss Henry's account, which she communicates with me through that account. It looks like she sent a text message to the victim, Miss Newsom, June 21st. There's only one text message that was received. The text message relates to Miss Henry's child. It states that her son will be with me all July 4th weekend. That is the one text message. According to this, the no contact order states that she's not having any contact with her except through their family court proceedings. As of right now, there's no family court order in place. They have a hearing scheduled for July. The only court order that's in place, to my understanding, is regarding a Judge Hessen case. Ms. Henry is also on probation with Judge Hessen for a domestic violence case. In that no contact order, Judge Hessen issued a no contact order stating that she's not having any contact with her son's father, who is Jason Haney, who is the victim's son. It also states that the no contact order, as people include their child custody, should be done through third parties, meaning that Destiny's parents should be communicating with Ms. Newsom and keep the parents out of the situation, that it's just the grandparents that should be communicating regarding the child's custody agreement. That's why I issued the violation regarding this.
I'm sorry, I'm a little confused about the relationships with everybody here.
Yes. So Miss Henry has a child with Jason Haney. They have a son together. Miss Newsom is the mother to Jason Haney. So she's the mother, she's the grandmother to Miss Henry's son.
And the content of that was the child will be with me
July 4th, yeah.
July 4th.
That was the text message that was received. It was regarding her child. But again, as far as I'm aware, no contact order states that they're only to be communicating through third parties.
If I may, Judge.
Yes.
Grandmother, so to speak, is the victim in the stalking case that is before his office.
That is correct.
Do you have any questions of Ms. O'Donnell, Mr. Kerman?
I would just ask, I believe you already said Ms. O'Donnell, but there's one sole text message at issue.
That was the only one that I received from the victim. That's correct.
And it states, I believe, Deborah will be with me all July 4th weekend.
That's correct. It is regarding her child.
Said this was June 21st.
I'm sorry, let me double check. June 21st, it's
At 12:34 p.m.
Yes.
No further questions.
Do you want to add anything, Ms. Newsom? I issued this entered the bond, I should say, issued the bond on May the 27th. Is that the only contact that you've had?
Since that hearing, yes. Before, tons.
Right.
Since the hearing, just that.
Okay. Do you have any other questions, any other testimony, anything you'd like to say, ma'am?
I just want her to follow orders. Me and her mother is doing communication for custody. I do not want any contact with her.
Anything else?
Your Honor, I would ask Ms. Newsom, Devereaux is, my client's son, correct?
Correct.
And your son's son?
Yes.
Again, there's currently proceedings for child custody in the Wayne County Circuit Court.
Correct.
And just involving Devereaux. Correct.
Yeah.
Okay, thank you.
Does your client wish to testify?
No.
All right, any argument at all?
Want to? Does not wish to testify, Your Honor.
Any argument anybody have?
Your Honor, I would simply indicate that, I believe the court was clear. There is a highly functioning relationship between the two grandmothers. The other grandmother is in the back pew, if you could raise your hand.
Okay.
So the communication is highly effective to uphold any, what if any, parenting time the young lady wishes. She violated a court order. There was no reason, because there's no breach of communication between these two grandmothers. In essence, Judge, at least as far as looking after Devereaux, these two grandmothers are on the same team and they have his best interest at heart. The whole reason for being in court on this matter was the stalking for this young lady. So I believe this does beyond or by the standard of proof before the court for this, which is not guilty on a reasonable doubt. I believe it does constitute a violation, and I would ask the court to make such a finding and leave any sanction to the court's obvious discretion.
Your Honor, this is actually very simple. It's being made out to be more complicated than it needs to be. My client does have an ongoing case with Judge Heston. That's dealt with in the other courtroom. As far as in your courtroom, Your Honor, on the bond sheet, but you specifically wrote, with an exception to the no contact order, it's a little difficult to read the handwriting specifically, but I believe that it says, except in conjunction with custody proceedings in circuit.
In conjunction with circuit court proceedings.
Circuit court proceedings.
I think what I meant was, I know what I meant, is that if she runs into her in the circuit court, that's not going to be deemed a violation of the no contact. If there's something that happened in the order, I don't know exactly what the circuit court order was. Does the circuit court order provide for any kind of contact?
No, my son had told the circuit court that I did not want any contact with her because of prior instances, that I was willing to mediate for him since they couldn't do the mediation because of prior charges. So he said that I'm willing to speak with her mother and do communication exchanges. She agreed, and that's just how that.
Look, there is no question that you violated the no contact provision. You had no right to go direct her. No, I'm not going to violate your bond and lock you up for this, but I'm going to caution you. There's not to be any contact at all with Ms. Newsom. Do you understand that? Yes? I can't hear you. I find that you violated the no contact provision. You had no business having direct contact with her. So I'm telling you, if it happens again, I'm not going to hesitate to set a high bond. and you'll be sitting in jail awaiting trial on this. Do you fully and completely understand? I can't hear you.
So Your Honor, just for clarity, just for what you wrote on the bond sheet there.
Yeah, it says, except in conjunction with circuit court proceedings. This has nothing to do with a circuit court proceeding.
Well, I mean, my client indicated that to me it did because they had a circuit court proceeding scheduled on July 13th. She was just, I mean, it's custody, it's visitation.
But she's not a party to the circuit court proceeding. Miss Newsom here is not a party to that.
But my client has indicated that she's very involved.
It might, well, because I was saying, I know what if I didn't say except in conjunction, except to effectuate visitation or custodial exchange with minor children. I did not say that. What I was saying with my except in conjunction with circuit court proceedings goes and she's there. I'm not going to have somebody come in here and say she violated the no contact. She showed up, she was there, and the defendant was there. That's all I was trying to clarify.
I understand, and that's the clarification I was seeking.
I understand. But this young lady knew that. And I'm telling you, you're playing with fire. Do you understand what I'm telling you? I can't hear you. All right, so are you guys, I'm going to find that there was a violation. I'm not going to change the bond. I'll continue the bond. Are you guys going to go and try to pre-try this?
Yes, sir.
All right, good enough. That's what I'll do. And when you come back in front of me, maybe you're soft-spoken. We got to pick you up. You got to have your voice about 40 times the decibel level that you have it now, okay? Thank you very much.
Thank you.
Thank you. You want?
Alrighty, friends, it's TCF Live on a Wednesday. Let's keep moving along. We'll probably come back to Judge McNally at some point, but let's go back to Judge O'Donnell, new contestant there.
190. We are here today for a change of plea hearing, and the defendant is present with Jim Matthews. The state has extended an offer to a lesser included of count 1, that being an F4 possession of fentanyl with a forfeiture specification. It's the state's understanding the defendant is going to withdraw his previously entered plea and enter a guilty plea to the lesser included of count 1, that F4 possession of fentanyl. If that plea is forthcoming and accepted by the court, the state would then ask for a pre-sentence report and drug and alcohol evaluation. Thank you.
Mr. Matthews.
That is correct, Your Honor.
Mr. Ryan, how old are you?
37.
How far did you go through school?
Completed college.
Are you a U.S. citizen? What?
Completed high school, went to a little bit of college.
Are you a U.S. citizen?
Yes.
Are you able to read, write, and understand the English language?
Yes.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
Yes.
What have you taken?
My prescription, alaprazam.
What's that for?
Anxiety.
When did you take that?
This morning.
Does it affect your ability to understand what's going on here today?
No.
Did you get a copy of the indictment?
Yes.
And it is my understanding that you were going to plead guilty to the lesser included offense in count 1. That's possession of a fentanyl-related compound, a felony of the 4th degree, as well as the forfeiture specification. Is that your understanding?
Yes.
All right, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you. And I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you questions. If you don't understand the question, stop me. If you want to talk some more to Mr. Matthews, let me know and I'll give you more time. Do you understand that?
Yes.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them testify. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the right to testify at trial if you want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you file an appeal, you have a constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford to hire a lawyer, one will be provided at no cost to you. Do you understand that?
Yes.
If you file an appeal, you have a right to have a copy of the transcripts that are generated in this case. Do you understand that?
Yes.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes.
Do you have any questions about any of these rights?
No.
Do you still want to plead guilty to this charge?
Yes.
Do you understand by pleading guilty, you're fully admitting your guilt to the charge?
Yes.
You understand by pleading guilty to this felony, you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control.
Yes.
The lesser included offense in count 1 is possession of a fentanyl-related compound. It's a felony of the 4th degree. It carries an 18-month maximum prison sentence and a $5,000 maximum fine. Do you understand that?
Yes.
If you plead guilty to the forfeiture specification, you're voluntarily giving up the items listed in that specification. Do you understand that?
Yes.
Are you presently on post-release control to the parole authority?
No.
Do you understand your guilty plea may result in a driver's license suspension of between 6 months and 5 years?
Yes.
You understand your felony conviction will prevent you from owning or possessing a firearm?
Yes.
Do you understand if a prison term is imposed in this case, you might have to serve a period of post-release control as part of your sentence for up to 2 years under the parole authority?
Yes.
If you are placed on post-release control and violate any conditions, the parole authority could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes.
If that violation is a new felony, you could get an additional consecutive prison sentence for that violation. Do you understand that?
Yes.
If that were to occur, the maximum prison sentence for the violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes.
Do you understand that if a prison term is imposed, you are eligible for judicial release?
Yes.
You could be placed on community control for up to 5 years, but if you violate any conditions, I could sentence you to prison for 18 months. Do you understand that?
Yes.
Has anybody promised you I would be lenient on you just because you're pleading guilty today?
No.
Has anybody promised you what I will sentence you to in this case?
No.
Do you understand I do not have to follow a sentencing recommendation of either the prosecutor or your lawyer?
Correct.
Have you had enough time to talk to Mr. Matthews before pleading guilty today?
Yes.
Has he discussed everything about your case and answered all of your questions?
Yes.
Are you satisfied with the advice he has given you?
Yes.
Have you been threatened or coerced in any way to plead guilty today?
No.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes.
Do you have any questions?
No.
Ms. Bell, if the case went to trial, what would the evidence show?
Thank you, Your Honor. Had this matter proceeded to trial, the state would have proven beyond a reasonable doubt that on October 24th, 2025, the 911 was called because the defendant was having a medical emergency. Police responded to the home, and it was found that the defendant was in possession of a fentanyl-related compound, pressed M30 pills, and by agreement of the party, the amount of the fentanyl was greater than 1 gram, but less than 5 grams.
All right, Mr. Matthews, anything to add to those facts?
No, Your Honor.
Mr. Ryan, did you hear what Ms. Bell said? The facts would show if this case went to a trial.
Correct.
Are those facts true?
Yes.
What is your plea to the lesser included offense in count 1, possession of a fentanyl-related compound, a felony 4?
Guilty.
What is your plea to the forfeiture specification?
Guilty.
Mr. Matthews?
Thank you, Your Honor. Prior to the hearing, I did review the written plea of guilty with Mr. Ryan. He indicated that he understood it and that he intended to sign it. Put the date there, 6/24.
Your Honor, I witnessed the defendant sign the written plea of guilty. Mr. Matthews and I have signed the same.
Mr. Ryan, is this your signature on the written plea of guilty?
Yes.
Did you sign it voluntarily?
Yes.
Do you want me to accept your written plea of guilty?
Yes.
I'll accept the written plea of guilty. Defendant was present. Mr. Matthews advised of all of his rights. Made a knowing, intelligent, and voluntary waiver. He understands the nature of the charge, the consequence of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, and voluntary. Will accept the plea of guilty and find him guilty of the lesser included offense in count 1, possession of a fentanyl-related compound, a felony 4, and the specification. I'll refer this for pre-sentence report, drug and alcohol evaluation, sentencing to be August 7, 9:30. Bond is continued. Anything else, Ms. Bell?
Nothing further, Your Honor. Thank you.
Mr. Matthews?
No, Your Honor. Thank you.
Alrighty, friends. So judging from the stats that YouTube is feeding me right now, it would appear that we have a lot of new friends out there this morning. If you have not already, do take a moment and say good morning to us in the chat. We're a friendly folk here. You'll love us. Let's go to Texas. Judge Stevens.
I was.
You're Nathaniel Clyde?
Yes. I was a court appointed attorney, and I was just informed that he has retained counsel, so I'm going to step back and turn it over to
And you are Mr. Manning?
Yes, Your Honor.
Okay. So let's see. You're charged with, you're Nathaniel Claw.
Yes, sir.
Do you understand you've been indicted, and this was 7 months ago, for the 3rd-degree felony of operating a motor vehicle in a public place while intoxicated? You have, though, that's not the worst part of it. You've got prior convictions.
You got it.
Don't interrupt me. When I'm through, you have a fair opportunity. Okay. There's, according to the grand jury, in 1997, you were convicted of illegal possession of marijuana out of Wichita Parrish, Louisiana. My family's right. Then the 3rd paragraph goes on to allege that after that felony of illegal possession of marijuana was finalized, you committed the offense of aggravated battery and were convicted in Wichita Parish, the same 4th Judicial District Court, of that offense of aggravated battery in 99. So,
Quick pause. Tim, thank you for gifting my 5 memberships. Appreciate that very much, sir. Thank you.
if you are convicted of this 3rd-degree felony of operating a motor vehicle in a public place, and if these 2 other priors are indeed valid, then you're looking at no less than 25 years imprisonment to life in prison. Do you understand what you're facing according to this indictment? Yes or no?
Yes.
Okay, as long as you know that. And also, you're not eligible for probation for this office. So what are we going to do? Mr. Manning.
I'm sorry, go ahead.
Oh, yeah.
I'm just going to the situation.
Yeah, well, that's what happens when you I was a defense attorney a long time. So those things fall in your lap, but I don't wait around. I move forward. Especially when it was indicted last year.
So believe that we're working on the discovery.
What is that? Okay, it's 7 years. What happened to the guy before? I think he was representing him.
John West.
Well, John, you had him for 7 months. Did you pass all the information to Mr.?
No, I had him for 7 months. He's been following. I wasn't appointed that. I'm not sure when I got appointed. I was appointed recently. I've only had one court date here.
And at that court date, Mr. Clark did not appear. He had a failure to appear, and you increased his bond to
You were the
$100,000.
attorney in January, as of January. And there was an initial docket. It was reset until February, and then that was reset until March.
Yeah.
Then that was reset until May, and then that was reset until later in May, and then that one was reset to, I think, today. Yeah. So what is that, 5 resetting? Bad gum. Come on.
Yes.
All right,
I don't know if off the top of my head, Your Honor, I can't.
Have you related things to your prior counsel as far as the office?
Yeah.
How often was it?
Yeah, we did.
Well, we didn't get a chance to get to that. So it's 4 versus 4.
what are y'all gonna do? What are you gonna do?
Well, I have concerns with Mr. Clark because he failed to appear. You increased his bond to $100,000. He posts the bond the next day. He gets out and he's alleged to have committed a new assault, family violence.
I'm not aware of that.
I filed a motion to increase his bond, and that is actually what this is set for this morning.
Okay, I'm looking at it.
Yes, sir.
And what happens, you tip me off ahead of time.
I apologize.
That's okay. This was filed on the 9th, but when it goes into the file, I don't see it until I break open the file of the docket. This states he's accused of family, an injury to a family member in 26 CR 1567. Can you pull that for me?
Gotcha. 08766. Sorry, what did you need, sir?
So you tell me.
26 CR 1567.
If you're interested about the PC, Judge, I have that from the.
I just want to know. I want to look at when that got filed, and
It was filed on June 5th. The offense occurred on June 3rd.
I can go.
why did we increase his bond?
We increased his bond because he didn't appear in court properly on May 27th.
Did you know?
And the next day he goes down to. Actually, he goes down to the jail that day and posts the $100,000 bond, and then within 5 days, he's alleged to have committed a new offense.
Did you know that he was courtroom?
Why would I know that, sir?
No, so he did our counsel like anybody had to do that.
Again, why would I know that?
Right.
I thought you were clairvoyant.
I've been told a lot of things. That's
But
not
not
one
Claire.
of them. No, sir.
First name has not been known as Claire.
No, sir.
Well, that's what he just related to here. There's issues here. Moving in another court.
I don't care. What I care is that he was out on bond and commits a new offense.
Yeah, well, no, I'm saying as far as it looked accessible, the failure to appear.
Sometimes it's
Sorry, Judge.
Sometimes it's amusing.
He
just listening
keeps
to you.
visiting with me instead of Your Honor.
He's trying
Yes,
to
sir.
figure it out.
Yes, sir.
I was a defense attorney for a long time, and things always surprised me. I was the last to know a lot of information about my client.
Well, now, as far as that goes, Judge, he has taken the original step to go through the portal to get discovery. I've seen the initial email and the response from the district clerks, but that has not been cleared. He's going to have to get with the clerk's office because he's new to the system. And so he has not had access to the Correct.
Okay.
We don't have their files and our cannot have access to get looked at. If Mr. Ham has the PC, that might be the only way. we can
Do you
get
have the information?
At the PC here, and I can print you out that, Judge.
Thank you.
Yes, sir. Give me one moment, Judge.
Sean Miller, Hamilton. Thought my boss and your boss talked about this, and I go, but don't move, so I'm just gonna go do the thing and look down later. Yeah, didn't trickle down last week. So he said it all, but I don't know anything about it. Supposed to play it.
We haven't probably this.
I haven't seen it.
Okay, we'll make a copy.
It's gone. Go to August. Okay, cool. Did you see is the original was the original for only 10 signs that correct? Sorry.
Yes.
Curious, was it any analysis suggest why they go from 2 to 1?
Not didn't appear for
Typically, they don't show. Is that a typical case?
That was his decision, not mine.
It's always my decision. There's no litmus test except for the circumstances of the situation. The thing was, I felt that was.
Sure.
When did he, when was the bond, increase?
May 27th. 2026.
Yeah, it was because, it was, a date for a plea. According to the attorney, and he failed to appear. Thank you. Oh, it's not for him. Thank you. It's wonderful. Good things. That's why that bounced up.
That's why it's required because
There's always a reason. It's just a matter of figuring out what it is. Generally, I double it, but if there are other circumstances, and that's, I rely on representation from the attorney and the defendant, and then if they don't, you know, they can always change their mind, but they need to be present.
Yeah, obviously not.
You want anything else from that misdemeanor file? Do you want anything else from the misdemeanor file?
It's waiting on the Impaired case.
All right. Okay, Mr. Manning, what are you gonna do with that? From the defense side.
As far as today, I actually was thinking about West, he's on his tax, required because if he can come back to Monroe and move back with his family.
Sir.
If he can come back to Monroe and actually have his home confined in Monroe.
What am I, why?
You entered a condition on his bond of home confinement after his failure to appear on May
Whatever,
27th.
well, he's on home confinement, whatever his home is.
His home is here. His home is here, Judge.
Yes, so if it's here, but I mean, if he moves to another home, that's okay with me. But it would be home confinement. But here's the problem is that I've got this motion now for an increase in bond, and I've got the information that's been filed that alleges a misdemeanor of assault on a family member, which is never. It's serious because if you're going to assault a family member, what are you going to do to someone that you don't know? And hold on, and this occurred on or about June 3rd is what this alleges. And this was filed on June 3rd. And what had happened was, unbeknownst to me, a week later, the defendant was here on June 10th. Right?
Not to my knowledge.
2 weeks ago?
Not to my knowledge.
Well, who's that? No, since I've got 5,000 cases, I have to see on that date, it was set for that. And that was reset.
That's a notice based upon the motion I filed. It wasn't his appearance, Judge.
This case is reset on the hearing. Yeah, okay. On 6/10, when this case is reset for a hearing on 6/24.
They reset, they actually set.
He was here on 5/29.
He was not here on 5/27. He gets out on the new bond, alleged to have committed a new offense. I filed a motion to increase his bail on June 9th. The court on June 10th set it for a hearing today on that motion to increase. The logistics are, he now has a new lawyer who hasn't had any access to the discovery.
Well, we still, notwithstanding that,
Yes,
we're going to take up the matter of a bond.
Yes, sir.
All right, what are we going to do today, gentlemen, on the motion to increase the bond?
In our position, the $100,000 bond, that was significant bond in this situation. You're reading about with his wife, or they're going through a divorce. And these are just these allegations that she made, suggesting that she was injured with a wrist injury. I hadn't seen any medical records to support that, not saying that, anything didn't occur, but she's claiming that significant or some injury occurred. I believe that the $100,000 bond is, and also he's in a position where he wants to live back home, and he's now filed for divorce to get away from her. So I don't know if that's going to be an issue. I know situations with other than the last 10. She's in a situation where she's basically trying to hurt him, with him not want to be with her.
What's that say?
Oh,
This has been looked at by our office. I've actually talked to this complaining witness. The probable cause sets out the facts there. We've determined that there's more than sufficient evidence to move forward with the accusation. And the problem that we've got here is a man who has a criminal history, who's out on bond, who just recently got out on an increased bond, is alleged to have committed a new offense, and it shows a danger to the community, not only to Ms. Clark, but to anybody else. The theory that there may have been some divorce filed is insignificant compared to what the accusation. The bond needs to be addressed. $100,000 is not sufficient. It needs to be increased at a minimum.
Mr. Manning, what do you ask? You kind of knew that all of it, but sometimes you get thrown into the game when you're warming up.
I believe that even with the $100,000 bond within this court, I believe it's custody line, central discretion.
Yeah.
So, but I think it went from 10, I believe it was originally 7, and it went to 10.
There's no,
and then it went to 100. So
because that was the third time we had to increase it, right?
Well, I think
Judge, not to interrupt Mr. Manning, but I believe the whole reason why you increased it is you felt like 10 was insufficient based upon his criminal record. And then with him not showing, it just made matters worse. And that's why you entered the amount, Judge.
What bothers me too is he's got an aggravated battery conviction, assaulted. It's assaulted of nature. And here we are on my watch when I have allowed him out on bond. He's accused. There's a charging instrument now filed with probable cause that states that you committed another assault. You know, this dangerousness to the community is enough and probable cause to believe that you've committed a crime is good enough for me to raise your bond again. But and let's don't forget, you're a habitual offender. You got no room for mistakes, especially assaulting, being accused of assaulting a girl. When I grew up, that was laughable. You don't assault girls, a man. Your bond is increased to $200,000. You understand? And the same conditions will apply. If you get out, you're at home, but you have no contact with any victim of a crime, including this. And you have to have a GPS device. And you can't leave the house except for food, to see your lawyer, for medical needs, in the most direct route possible. Anything else? You raised your hand. What do you want to say?
You don't get accused. Not true, I get accused.
Probable cause is enough for me to raise your bond, sir. You've the probable cause to believe you've committed another crime. And here's probable cause affidavit. Your attorney has a copy of it.
He has a copy.
Thank you, Judge.
He
may actually already have he should already actually have the GPS from the car.
Yes.
And before he leaves, before he's taken in, before he's taken to jail, I'm going to test him to see if he's on any kind of controlled substance. What are you going to do next, sir?
So we need to reschedule.
Yeah, you don't want to, is 2 weeks good? Something be done in 2 weeks, you think?
Then if I talk to the clerk, with the issue. Send an email. I don't know if.
3 out of Louisiana?
You say you found this from.
Well, I mean, have Louisiana people ever come?
Yeah, that's why.
Fix it.
I think he's gonna go back to the district clerk.
Okay, it's fixable.
Yeah.
Just if you have a problem, talk to the staff. They can help you go through it. Yes, sir.
Judge.
Alrighty, friends, we will keep an eye on Judge Stevens' court. Might go back later, but let's head up back to Michigan and one of the newer crowd favorites here at TCF. This is the judge, in case you're not familiar with her, who oversaw the Larry Nassar case. This is Judge Aquilina.
All right, this is docket 25-1145-FH. People of the state of Michigan versus Michael Wayne Barnes Jr. Counsel, your appearance for the record.
Good morning, Your Honor. EPA Bart Buxton on behalf of the people of the state of Michigan. Good morning, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Michael Barnes, standing to my right this morning.
Thank you, sir. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury? Thank you. Put your hand down. I need you to keep your voice up, sir. Have you taken any medication, alcohol, marijuana, anything yesterday or today?
No.
Are you supposed to be on medication you're not on?
I'll get back on it.
Is it anything that would interfere in your ability to understand your attorney?
No.
And any sign of fever, COVID, or other illness?
No.
And you've had enough time to speak with Mr. Feigelson? And you've reviewed the pre-sentence investigation report?
Yes, ma'am.
Thank you. Sir, counsel, move the microphone closer to him. You need to keep your voice up, all right, sir? All right, and sir, you pled to weapons carrying concealed punishable by 5 years. Recall that? All right. On behalf of the people, any corrections, additions, deletions?
One brief correction to the body, Your Honor. On the cover sheet, in the plea agreement section, it states kilogrew/Cobbs. I want to make it clear it was just a kilogrew agreement, so I believe that Cobbs should be crossed off.
No objection, I think that
That's accurate. I rarely do comps, so I would remember that. All right. And is that then under evaluation plan or anything else? Let me just
I
look.
don't believe so, Your Honor, but let me double check.
I didn't see it, Judge.
All right, I don't see it either.
I don't either. It looks like it just is referred to as a kilogrew evaluation.
Yeah.
Okay. Thank you. And any other corrections, or was that it?
No other changes to the body or the guidelines, Your Honor.
Mr. Feigelson?
No other changes other than the one pointed out by Mr. Buxton, Your Honor, including the guidelines.
Thank you. On behalf of the people?
Yes, Your Honor, I do believe that the recommendation is appropriate from probation, given the defendant's lack of a criminal history. I do think that a weapon safety course would be appropriate, but besides that, Your Honor, I'm in agreement with the recommendation. Thank you.
Thank you. And counsel?
Yes, Your Honor, I do support the recommendation. You want to point out, I believe, prior to taking the plea, Mr. Barnes did complete a weapon firearm safety course, and I believe that verification was given to probation at the time of the pre-sentence interview.
Sir, you completed a class?
Yes, ma'am.
Larry? Oh, yes, I do. I'm looking in the evaluation plan in the 4th paragraph. It said, or says, defendant completed a firearm safety course and verification was provided.
It does, Your Honor. Thank you.
All right. Sir, what would you like me to know? Well, I understand that. So tell me this, what have you learned from this?
Put your stuff up yourself.
Follow the law, pay attention, follow through. Yes? All right. Sir, I am going to sentence you to 1 day jail credit for 1 day. And you'll pay a crime victims assessment in the amount of $130 and a $68 state costs. That is $198. How much time do you need to pay for that?
Due date about right.
Okay, so I'm going to give you until October 31st, just in case you forget. I hope so, because that'll close the case. Okay.
Good enough.
All right, so I want you to pay it by Friday, but just in case, life has a way of happening. So by Halloween, you're going to pay it, otherwise late costs come in, and the state's not very kind about that. So that's why I gave you some time to pay. Friday would be perfect because then we'll close the case. You have 42 days to appeal and to request appellate counsel. The weapon and any contraband ammunition was already seized or forfeited. So I think we're good. 42 days to appeal and to request appellate counsel.
You have a copy of the form, Mr. Barnes?
All right. Any questions, sir? Good luck to you, sir. Thank you. Next matter.
Yes, Your Honor, it'll be Adrian Del Toro.
Michael Barnes. Where is it?
Page 3, second one on page 3.
I hate this new form. I can't find it. I know, it's weird. Next.
Adrian Del Toro, Your Honor.
We have documents to be signed, Your Honor.
So final pre-trial, is this going to be a plea?
It's going to be a plea, Your Honor.
You send them.
I'm signing.
Yeah.
Judge, it's gonna be no contest plea to, intoxication.
Okay. You. All right, this is docket 25-6717 FC, People of the State of Michigan versus Adrian Del Toro. Counsel, your appearance for the record.
Good morning, Your Honor. AP Bart Buxton on behalf of the people of the state of Michigan.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Adrian Del Toro this morning. Your Honor.
Thank you. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes.
Thank you. Put your hand down. Have you taken any medication yesterday or today?
Oh, yeah.
Is it anything that would interfere in your ability to understand the court or your attorney?
No.
Is there medication you're supposed to be on that you're not on? And you need to speak up, sir. This record isn't for me, it's for you, so it needs to be a good one, okay? Is there medication you're supposed to be on?
No.
Any sign of fever, COVID, or other illness? Have you had enough time to speak with Mr. Feigelson?
Yes.
All right, thank you. And are you a US citizen?
Yes.
And I understand that there's not going to be a final pretrial, that you've chosen instead of going to trial to plead today, is that correct?
Yes.
And are you a US citizen?
Yes.
All right, do you generally work? When you're not in custody, do you have a job? What kind of work do you do?
I haven't worked in a while. Yeah.
What kind of work do you do? Odd jobs, what?
Yeah, like construction jobs.
Construction, okay. Did you graduate high school?
No.
You have a GED? How far did you make it in school?
10th grade.
Okay. And I have an unknown address on the felony information, and I noticed on the advice of rights form, we didn't put an address other than the jail. Are you homeless?
Yes.
Do you have family you can live with or any other?
Yes.
You do, and why aren't you living with them?
Oh, I just got there like 2 days to move in and I can.
Okay. On behalf of the people, what is the plea agreement?
Yes, Your Honor. The defendant will be pleading to count 3, carrying a concealed weapon, which is a 5-year felony. Count 4, resisting or obstructing a police officer, which is a 2-year felony. And felonious assault or assault with a dangerous weapon, which is going to be an added count 6, which is a 4-year felony. Upon successful plea and sentencing, count 1, armed robbery, count 2, carrying with unlawful intent, and count 5, resisting and obstructing a police officer will be dismissed. And in addition, the habitual offender 4th will be reduced to a habitual offender 2nd offense notice.
Full, fair, accurate, and complete.
Yes, Your Honor.
Counsel, I'm sorry, sir, full, fair, accurate, and complete the plea agreement that was just stated on the record. Is that your understanding?
Yes.
And there'll be a no contest plea because of intoxication and ultimately also because of civil liability. And counsel, are you waiving reading counts 1, 2, 5, and the habitual 4th?
Yes, Your Honor.
So on the sheet that has a sentence agreement, I am adding, because I don't see it here, it just says he's pleading to the habitual 2nd, but I'm adding the habitual 4th will also be dismissed.
Understood. Thank you, Your Honor.
Okay, just for clarity, may I have the original? All right, as to the reading of the felony information.
Yes, Your Honor. People of the State of Michigan versus Adrian Esparra del Toro. State of Michigan, County of Ingham. In the name of the people of the State of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on the date and at the location described below, the defendant in count 3, weapons carrying concealed, on or about November 19th, 2025, at 221 Mack Avenue, East Lansing, Ingham County, Michigan, the defendant did carry a dangerous weapon, to wit, a non-folding stabbing instrument concealed on or about his or her person, contrary to statute. As charged, that is a felony punishable up to a maximum of 5 years or $2,500 with mandatory forfeiture of the weapon or device. Count 4, police officer assaulting, resisting, obstructing. On or about November 19th, 2025, at 221 Mack Avenue, East Lansing, Ingham County, State of Michigan, the defendant did assault, batter, wound, resist, obstruct, oppose, or endanger Jason Cotton. Cotton. Thank you. A police officer of the East Lansing Police Department that the defendant knew or had reason to know was performing his or her duties, contrary to statute. As charged, it is a felony punishable up to a maximum of 2 years and or $2,000. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement, or under MCL 750.81D6 for another violation arising from the same transaction. And added count 6, assault with a dangerous weapon. On or about November 19th, 2025, at 221 Ann Street, East Lansing, Ingham County, State of Michigan, the defendant did make an assault upon Ian Anthony McClellan with a dangerous weapon, to wit, a non-folding stabbing instrument, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder, contrary to statute. As charged, it is a felony punishable up to a maximum of 4 years and or $2,000. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. Habitual offender second offense notice. Take notice that the defendant was previously convicted of a felony or an attempt to commit a felony, in that on or about November 12th, 2024, he or she was convicted of the offense of attempted police officer assaulting, resisting, or obstructing in violation of MCL 750.81D1 parentheses A in the 66th District Court for Shiawassee County in the state of Michigan. Therefore, the defendant is subject to penalties per statute. That penalty being 1.5 times the maximum sentence on the primary offense or a lesser term. The maximum penalty cannot be less than the maximum term for a first conviction. For count 3, Your Honor, that would make the maximum 7.5 years. For count 4, Your Honor, that would be a maximum of 3 years. And for the added count of felonious assault, that would make the maximum 6 years. The court shall order law enforcement to collect DNA identification profile sample before sentencing or disposition if not taken at the time of arrest and against the peace and dignity of the state of Michigan.
Sir, did you understand what was just read?
Yes.
So you understand count 3, carrying a concealed weapon, normally punishable by 5 years. Because of the habitual second, it is 1.5 times. So therefore, there's an enhancement to up to 7.5 years. Count 4, resisting, obstructing, normally punishable by 2 years, is now punishable by 3 years. And felonious assault is normally punishable by 4 years, but with habitual, again, 1.5 times would be up to 6 years. Do you understand how that works?
Yes.
And it looks like you signed the advice of rights form. Did you read it before you signed it?
Yeah.
Did you understand what you read and signed?
Yes.
If you had any questions, were you able to ask those of your attorney?
Yeah.
Do you have any questions about your rights in this court?
No.
And you've chosen to plead. Have you chosen this of your own free will, no one forced, threatened, coerced, or promised you anything other than the plea agreement? Is that correct?
Yes.
And you made this decision after talking with your attorney?
Yes.
And you've been satisfied with the representation of your attorney?
Yeah.
And Mr. Feigelson, he indicated earlier that he had taken some medication. Do you believe he's oriented to date, time, and place, and does understand what's occurring?
I do, Your Honor.
Thank you. Sir, as to count 3, carrying a concealed weapon, I understand you're pleading no contest based on civil liability and intoxication. So as to count 3, weapons carrying concealed, how do you plead?
Contest.
And as to count 4, police officer assaulting, resisting, obstructing, how do you plead?
No contest.
And as to count 6, felonious assault, how do you plead?
No contest.
And sir, has anyone told you what I will do at sentencing? I know you look at me like it's a trick question, everyone does, but it's really not. I just need to make sure that no one's promised you something else, so we have to ask things in a number of different ways. That's the right answer. No is the right answer because I don't know much about your case. I am going to learn a little bit today, but I don't make up my mind what I will do until I'm fully informed, and that's at sentencing. Do you understand that?
Yes.
Okay. Let's see, by stipulation of counsel, I have been provided a couple of pages of the police report. It is from the East Lansing Police Department, case report number 2536403436. The report date was November 19th, 2025, the date of the incidents. And it appears that the reporting officer was Jason Pass, and he has prepared this report. And it states that on November 19th, 2025, he was assigned day shift road patrol. He was in a fully marked squad car wearing a Class B uniform, making it clearly recognizable that he was a police officer on duty with the city of East Lansing. dispatch sent to him at 16:26 hours on that date, a broadcast that a felony was in progress for an armed robbery at Spartan Spirits 221 Ann Street. And that is in the city of East Lansing, County of Ingham, state of Michigan. At 16:25 hours, the reporting person, Caitlin, Kaitlyn Breagh, who was a customer inside the store, was originally reporting a troublesome subject who was harassing workers and making threats. And the accused description was a 50 to 60-year-old Hispanic male, last seen wearing a gray hoodie and gray sweatpants. And she advised that the male appeared to be on something. Law enforcement responded to the scene with caution, checked the area, and was unable to locate the suspect, but made contact with Spartan Spirits to ensure the accuracy of the suspect description and last known direction of travel. An initial contact was made with defendant with the victim, Ian Anthony McClellan, and the victim, Ian, I-A-N, Anthony McClellan, McClellan, who advised that he was unable to pull up the security footage until the store owner was on scene. He said that the owner was en route. He confirmed the description that was provided to dispatch was accurate and further advised that the suspect was a regular homeless subject who is normally seen wearing a hoodie with the hood up. He said that the suspect also had a part of his nostril missing. This suspect was later identified as Adrian Esparza, Esparza Del Toro, Deltoro, date of birth 2/4/1983. He confirmed that Del Toro's last known direction of travel was southbound MAC Avenue when he lost sight of him, and said that Del Toro stole some Red Bull, Fireball, and Buzz Balls, BUZZBALLZ''S. He described the knife that Del Toro used as a flat kitchen knife, and then McClellan used his hands to estimate the size of the knife, showing approximately 6 inches between his hands. Further, he said that he could tell Del Toro was getting irritated because of his body language while he was at the counter of the store, and that he appeared to be super drunk and was upset about a transaction that occurred in the store. Further, he said that Del Toro paid for items in the store and that another employee in the store was not giving him the items he paid for. The officer then observed Del Toro inside Puff Tobacco, and he was standing inside the store talking with an employee at the counter. He recognized Del Toro from a previous encounter with him and indicates that he has spoken to Del Toro on numerous occasions, as he's a regular homeless who stays in East Lansing. Due to Del Toro matching the description provided and being suspected of robbing Spartan Spirits at knife point, the officer unholstered his duty handgun and moved southbound to MAC Avenue, keeping his gun in the, what is that, SUL position?
Standard operating, I guess, or ready position maybe.
I don't know, it's some abbreviation, SUL, I'm not familiar with. SOP would be standard operating procedure, I don't know, well, regardless. He stepped southbound to clear my backup, or his backup, as there was an employee in the store. As he was stepping southbound, Del Toro started walking toward the officer and he yelled, "Come outside with your hands up," and the officer gestured with his hand, further instructing him to come toward him. Del Toro did not listen to the command. The officer again yelled, "Come outside," a second time while he was gesturing for him to come outside toward the officer, and Del Toro did not listen. He started to step toward the corner of the store where Officer Monroe advised she saw a knife on the ground. Del Toro was moving directly toward where Officer Monroe indicated there was a knife. Due to Del Toro moving toward a knife while there was still an employee inside the store, the officer, along with Officer Mercer, MEN-SER, decided to make entry. Collins said that he walked around the counter to remove Del Toro from the store and that he was concerned about the safety of his customers. McClellan advised that once he approached Del Toro at the front door, Del Toro pulled out a knife and started threatening him with it, and said that Del Toro said, "Do you want to die for this?" numerous times. McClellan gestured in a slashing motion with his hands while he recounted what Del Toro said to him. McClellan said that he was attempting to de-escalate the situation when Del Toro took a shot, and McClellan believed that Del Toro was amping himself up to come stab him. I think we have the elements. Do you need anything else read from this?
I don't believe so, Your Honor. The only thing is the habitual offender status.
Well, and I don't have that, but counsel would stipulate that defendant was convicted of a felony on or about November 12th, 2024, being convicted of attempt police officer assaulting, resisting, obstructing in violation of the statute in the 66th District Court for Shiawassee, State of Michigan.
I can stipulate to that, Your Honor, but I can also ask Mr. Dottore, do you remember getting convicted of an attempted RO in Shiawassee County in 2024? Mm-hmm. Is that a yes? Yes. Okay.
Then the people are satisfied, Your Honor.
Thank you. Counsel?
Okay. I'm satisfied as well.
Thank you. Our counsel were promises, threats, or inducements other than those already placed on the record.
No, Your Honor.
No, Your Honor.
The court will have the court.
You have, Your Honor.
Thank
Wait a
you.
minute, one at a time. Look,
You have, Your Honor.
You have, Your Honor. Sorry.
I could get it, but no. Don't get used to it.
I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made without undue influence, threats, coercion, or promises of leniency. I also find the no contest plea to be appropriate. It's clear in the police report that he was heavily intoxicated, and there's also an issue of possible civil liability. So no contest plea is sufficient and appropriate in this situation. I also find, based on the police report and the stipulation of counsel and the acknowledgement that there was a prior that the habitual second should go forward, and there are sufficient grounds for the entry of counts 3, 4, 6, and the habitual second. Counts 1, 2, 5, and the habitual fourth are dismissed, along with any outstanding warrants related to this file, if any. And any weapons or contraband seized are hereby forfeited. Do you have a sentencing date?
August 19th at 10:30.
I think I can make that work, Your Honor.
I'm not sure.
Fair enough.
I think that should be fine. If not, we'll let you know. I was thinking it was the week before, but all right. August 19th At what time?
10:30.
Okay. Sir, you'll need to cooperate with probation. They're gonna come and see you, for a pre-sentence investigation report. We can't go to sentencing without that. At this time, without verification of an address, I am not going to entertain a motion for release on bond, but if you'd like to have a bond report, get verification of an actual address, that's something I might consider in the future, but under these circumstances, no.
Yes, ma'am. We'll work on that.
All right, I'm sure you will. Thank you. Sir, you getting what you need in the jail? Are you getting what you need in the jail?
Sure.
Yes? Do you have an ID? Do you have a?
No.
Okay.
I lost
Okay, and that's why I'm asking.
it. I don't even know the address. I haven't talked to any of my family, so.
Okay.
I'm.
They have a social worker who can help you, and the other thing is, I asked you about the ID, because the jail does have a program where they can help you with that. So inquire about that and avail yourself of that, because without an ID, without an address, so you're gonna be in the Ingham County Jail where I can find you. I'm not gonna allow you to be wandering the streets, and the homeless shelters are full, and so there's a matter of safety, not just for you, but for the community, so. It's something we can work out later, maybe, the circumstances have to be right. I need to look at public safety as well as your safety. Do you understand, sir?
So our social worker will be in touch with Mr. Torson.
I'm sure they will. So, sir, while you're in the jail, avail yourself of getting an ID, attend CATS, AA, NA, start working on some things. All right?
No.
You're in all that? Very good. You doing okay?
Yeah.
Okay, I'll see you in a few weeks. Thank you. It's all for the record.
All right, friends, hour 3 of TCF Live. Let's go back to Texas and check in with Judge Stevens, new contestant.
You know, we're about to start the punishment phase in the trial here in a few minutes.
Yes, sir.
And that's why this works like a train station. You ever been on a train? If you're not there on time, they don't wait for you. They take off. That's the way it is. And then, look, this is a third-degree felony of child grooming, which is about the most disturbing crime you can be accused of. And then he's got a prior conviction of illegal possession of controlled substance. It doesn't say what it is, but in 95, in this court, before I was here, he was convicted. So this, if you're found guilty of this third-degree felony, the punishment range is bumped up to a second-degree felony if this prior conviction is proved, which means you're looking at up to 20 years in prison, and you are not eligible for probation. That's how it is.
You understand?
So what's not in this? Is the age of the child. It says under the age of 17, but nowhere in the.
About 15, Judge?
I don't know. You tell me, there's nothing that shows.
That was her age.
Of 15. Child. Any victimization of the child is never treated with happiness by this court, right? Should never be. What's the relationship to this
I
person?
believe it is his girlfriend's niece.
I need to assess.
Last day. Oh, yeah. Yeah. Making sure you use all powers to make sure it's more to come from Mr. Simmons. He's not mediation of the abstains. Oh, yeah, no. No, that's.
Okay. You had a copy of all this problem that was at the bank. It's all very disturbing.
And like I said, Judge, I can pick up the file this morning.
I know, what's this bond? I don't like this at all. This is terrible.
Oh, yeah.
This is terrible. It's a 15-year-old child that you're alleged to, according to this indictment, which you have a prior conviction, felony conviction, you don't need to be committing a crime.
25,000 under condition, there's no contact. The victim or it's
Secretly sending money to the child, then purchasing items for the child discreetly without the parents knowing it. Then you told the victim you're sexually attracted to her, repeatedly requested sexual intercourse despite the victim consistently refusing and stating she was not ready. She's a child. How old are you again? How old are you?
55, sir.
Sir?
I'm 55.
55 years of age. Victim reported physical conduct, including inappropriate touching of her leg. The family confronted you and told you to cease contact with the child. You later resumed contact, sending unsolicited cash monies and messaging the victim through social media and using a language that was sexual in nature. Digital analysis of your phone corroborated the contact. All of this screen, all its messages, pattern behavior, stick communication, emotional manipulation, sexual poverty, believe that you go something conduct to be later. Absolutely.
I think, friends, we're not going to hear the end of that because his audio just went kitty-wonkus. However, if the allegations are true, I probably hear cries for the wood chipper out in the chat. Okie dokie, let's do this. Let's go to Louisiana and let's say good morning to our good friends at the parole board.
Good morning, sir. Are you Tori?
Yes, ma'am.
Would you introduce yourself? Tell us your name and DOC number.
And then Tori Estem, DOC number 604002.
All right, Mr. Estem. I didn't know how to pronounce your name, so thank you. We're here for a revocation proceeding. You got any paperwork there with you this morning?
Yeah, it's paper you did give me.
Yeah, and that's let me see, is that the parole revocation questionnaire?
Number one? Yeah.
Did you sign that piece of paper at the bottom?
Yes.
So based on the information contained in that document, Mr. Estem, you're not eligible for us to appoint you a lawyer. So are you ready to proceed with the revocation proceeding without a lawyer this morning?
Yes, ma'am.
Okay, thank you. Your case has been assigned to Mrs. Ledoux. I'll turn it over to her.
Hey, good morning, sir. I'm going to be reading some allegations of violations against you, and I need you to enter a plea of guilty, guilty with a statement, or not guilty. On Rule 4 violation, the offender failed to refrain from criminal activity and was arrested on 1/21/2026 by Orleans PD and charged with illegal carrying of a weapon with a CDS, possession with the intent to distribute cocaine, P-Wid marijuana and possession with the intent to distribute tapentadol, whatever, some type of drug. How do you plead?
Not guilty to, she was going on my federal charge.
Also, number 5, you failed to refrain from possessing or controlling a firearm as evidenced by the new arrest. How do you plead to that?
Not guilty.
And number 10, you have not been paying your fees and you're currently $119 in arrears behind on your fees. How do you plead to that?
Guilty.
Okay. So your charges were not accepted by the New Orleans district attorney, but they were accepted by the U.S. Marshals. Is that correct?
Yes, ma'am. They picked it up.
Okay. And you have a court date August 13th?
Yes, ma'am.
Okay. Do you have an attorney for that particular case?
Yeah, I don't know his name, though. He got a double. I don't know, a double. So.
Okay. So those are significant charges. Have you been to court at all? Let's see, you were detained in April. So this is your first court date?
Yeah, my first court date.
Okay. I mean, these are significant charges against you. And it looks like NOPD is just allowing the U.S. Marshals to handle the case.
Mm.
Okay, so I want you to know, based on reading everything that I've read, I would be prepared to revoke you. And if you want to have that case looked at by the U.S. Marshals prior to us making a decision, I would be willing to continue the case until such time as they've made a decision.
Yes.
Ms.
I'll wait till they finish to see what they're going to do.
So, Ms. Chairman Renatsa, Mr. Tillis, do you have any input on that?
Well, I would, based on what I see in the record, I think the evidence supports new criminal conduct.
I do too. Yeah.
Firearm-related violations. I have enough information in my mind to vote to revoke.
Okay. I did too. Yeah, because I have enough. I think that there's a significant reason to believe without with preponderance of evidence that you have been engaged in criminal conduct. What would you like to say about the time, what happened, Mr. Estem?
Time of what happened with the charges?
Yeah, what happened?
I'm really just fighting the charges right now.
So you didn't, you were not involved in carrying a weapon while you were on
I was
parole?
really the police at the wrong time.
That's usually what happens. Why were you hanging out with people who were doing, what were the other people doing that caused them to get in trouble?
I was at a store.
Uh-huh.
I was at a store. I walked in the store and walked out the store.
Okay.
Mr. Epstein, did you have drugs on you or a firearm?
No, it said been thrown. It said it was thrown all over. And she just said she observed me.
Okay.
The video show otherwise. The video got a video show. She said I didn't do.
And so that video has been presented to the marshals, though, right?
Yes.
And a video doesn't lie usually.
The video don't lie. When she said she saw me dead, the video don't show that.
Okay. Um, so you were out from March of 25
Yes, ma'am.
until you were arrested in April.
Yes, ma'am.
Okay. I don't have any other questions.
Any other questions?
No, I don't have it.
So are you asking us to continue your case till after you deal with federal charges?
Yes, ma'am.
I'd be willing to do that based on his statement, Mrs. Ledoux.
Okay. My vote today would be to continue the case until after the U.S. Marshals adjudicates the criminal activity.
Mr. Tillis?
I concur to continue.
All right, and as do I, because the court date is in the near future. So, Mr. Estem, we're gonna continue. We're not gonna make a decision today. We're gonna let you deal with those charges, and we'll see you again.
Good, ma'am.
Bless you. Have a good day.
Thank you.
I think that was probably the right thing to do. Good morning once again, everybody. TCF Live in its last half an hour for today. Air Force had a question. Is bond and bail, are those two things the same? Often used interchangeably, but not exactly the same. They do mean two different things. Bail is the amount of money or property that the court requires for the person to be out of jail. The bond is the actual agreement for that. So bail is the monetary portion, the bond is the actual written agreement. That's basically the difference, just to make you aware. Okay, we're going to go back to Judge Stevens. Just an FYI, his audio did fix itself towards the very end of that last hearing. Long story short, they continued the case for another day, so nothing was really resolved or anything. But let's go back, new contestant.
Yeah. You wrote down? Yes, sir. Okay, we call 26 CR 606, the state of Texas versus Roy Thomas battle. Here with your attorney and the state's attorney, does the defendant waive a formal reading of the indictment and arraignment? Can we proceed with such?
Yes.
In summary, sir, this indictment alleges that on or about December 10th, 2024, wow, that was a while back, in Jefferson County, Texas, you committed the offense of operating a motor vehicle in a public place while intoxicated. Do you understand what you were charged with here, sir?
Yes, sir.
Paragraph, the other portion, the way it's written, paragraph 2, goes on to allege that prior to this event, in 2007 and 2013, you were convicted out of county courts at law of Orange County, Texas, and Jefferson County, Texas, for offenses of operating motor vehicle while intoxicated, DWIs. So 2 or more DWIs bump up a third charge to a third-degree felony. Do you understand where you are sitting on this?
Yes, sir.
A third-degree felony, if convicted, means you face no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand that?
Yes, sir.
An agreement has been reached in your case, you would be pleading guilty. And what? This says fine $250.
Oh, Judge, I'm sorry, I should have marked it. It's the sentence is 4 years, probated for 4 years. And
Is that right?
yes. And that's by agreement, Judge, that we're asking.
Okay, I'm going to put 4 here.
Thank you.
In this spot, 4 years, fine $250. And you can be placed on probation for up to 10 years. Do you understand?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir, I understand.
All boxes need to be checked.
And we're going to waive the PSC.
How do you plead to this indictment charging you with operating a motor vehicle while intoxicated in a public place, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
And those two prior convictions of DWIs out of 2007, 2013 county courts of law, Orange County and Jefferson County respectively, are those allegations true and correct?
Yes, sir.
And are you pleading true and correct to those allegations voluntarily, because they are true as they are alleged? So I'll show you what's marked as State's Exhibit 1. Here,
No.
Willard.
No objection.
Did you sign that document? Understand them, discuss, understand the contents? Is everything true and correct there?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection, it's admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with? The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You have your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You're totally satisfied with the representation provided by your lawyer. All of this is true. It states so help you God. State's Exhibit 1 is made a part of the record without objection. Defense or state? Yes?
Yes.
Done. Pre-sentence report is waived, right?
Yes, sir.
I'm going to follow this, say on the length of probation.
Judge, it is our agreement and joint recommendation for the 4 years of probation. Mr. Hall has presented substantial proof that Mr. Bowden, from the day after this incident, has worked everything on his own to try to reconcile this issue. He's provided proof that he's attended AA from that day forward. Your Honor noted during the initial time frame the delay our office took with filing this matter. And I will say, out of the 36 years that I've been doing this on both sides of the bench or the bar here, I've never seen anybody take such extended efforts on their own. So I'm trying to reward that conduct in hopes that he continues it, Judge.
And Your Honor, I have a letter I'd like to present that I wrote to Mr. Ham. It has 16 pages of AA. And
this shows all that proof, Your Honor, that I just gave you.
He got out of jail on December 10th. On December 11th, he attended his first AA meeting, and he has proof of that. And there's followed by 16 pages of AA sign-in sheets. His sponsor is here today.
What was the blood specimen? Goes out?
Judge, that was 0.153.
Twice the legal limit. And what I'm looking at here is in the probable cause. What's really disturbing is the violent nature of a fight and attempt to be combative with the officers when they were arresting you.
Your Honor, he's accepting that responsibility as well. He's going to enter. He's going to enter a plea down the hall on the resisting arrest charge for a probation that's going to run concurrent with this as well. There's no doubt his conduct on that night was horrendous, which is the reason why I wouldn't go any further than what I've done on this plea bargain.
He's very ashamed. And he is part of the recovery community down in Mid County. He goes to AA all the time. He goes to a recovery church, and we have
all that's great. All that's great.
It's great.
It's never too late, but this is the third time you were arrested and convicted of a DWI. So is this it?
Yes, sir.
Okay. One is too many, as you know, and we're here for 3. And it's never too late to fix it. Just because everybody comes in and talks about how remorseful they are. I'll say that. And then a lot of folks come back I'm going to follow this agreement. Okay. I'm going to find, and again, you are pleading guilty to this offense and true to the prior convictions in paragraphs 1 and 2, which constitute the third degree felony of operating a motor vehicle in a public place while intoxicated, 2 or more prior convictions. Based upon your plea of guilty and states exhibit number 1, there is enough evidence there that is admitted in these plea documents to support your guilty plea, to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt as I find you mentally competent to enter your guilty plea. It's freely and voluntarily made. You understand and appreciate the consequences of pleading guilty. I hereby find you guilty of this third degree felony. I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years. That's 4 years in prison. I'm going to suspend that term of imprisonment and place you on probation for 4 years. There will be terms and conditions of probation here that the probation office will go over with you, and you will be fined $250 as well.
And Your Honor, the state is willing to allow him to attend weekend time in jail for 10 days.
That's correct. I don't want him to lose his job.
Well, that's a risk you take when you do this, right?
Yes, sir.
How are you employed?
So,
How are you employed? What do you do? What kind of work do you do?
I'm a welder.
He builds tanks. He works inside of confined
But how much do
spaces.
you make an hour?
I make $33.
Yeah. Well, that's $70,000 a year. I mean, that's a fortune to a lot of people, which could lose either by flirting the trouble. Right. Under these terms and conditions of probation, there are 36 terms and conditions of probation. Most of these are the terms and requirements that I have to follow every day. So you will be ordered to serve 10 days in the county jail on successive weekends, beginning when? You all report on or before 6:00 p.m. each Friday.
Yes, sir. As soon as possible, next weekend. He's from jail.
July 3rd.
So it's July 3rd. Yes, July 3rd.
Beginning 7/3. So you also must have an auto ignition interlock system installed in any vehicle, and you will complete the Texas DWI offender program, which is what you need to do, but also it will help reduce and mitigate the cost of insurance that you get hit with for something like this.
Yes,
It'll mitigate that penalty that you're going to face. Okay. You understand what's happened today?
Yes, sir.
Okay. If you fail, your probation could be revoked and you could be sentenced to 4 years in prison. Please see the probation officer and do well. Thank you,
sir.
Yes, sir.
Your Honor, yeah, Coach.
Yeah.
Mr. Williams did show back up and he did test and then got the results back right there. Ellie has it in her hand.
It must be good for you.
They are, otherwise I wouldn't be.
Yeah, I didn't.
Yeah.
Okay.
Get her 4-week resetting.
Yeah, get a resetting.
Get resetting and good to go.
Here's this one. Who's next? Yours?
We just need a trial setting.
On who?
Lorenzo.
Who?
Lorenzo. That's when you get called earlier.
Where is he?
He's.
Come forward.
I'm going to give him a whole thing. Yeah, so
Okay, in 25 CR 863, you were Lorenzo Walker.
Yes, sir.
You're charged with the second degree felony with aggravated assault, causing serious bodily injury by striking the victim in the face with a piece of lumber, which caused serious bodily injury, apparently. And so the victim was transported to the hospital in critical but stable condition, including multiple broken facial bones and loss of teeth. Well, that can't be good for the infant. Thanks. Oh, no. What caused, is that what you do normally? Is that no? You have to speak out so she can take everything there. You're shaking your head. That doesn't count. You have to speak out. Did you know this person?
Yes, sir, I didn't know.
Okay. This is at 2:12 in the morning. Never anything good really happens about then. What's that saying on, what are we doing? Hey, Willard.
We've made an offer, they've rejected it, Judge.
This goes into Mr. Bell. Okay. You're asking for trial.
Yes, sir.
Let me just say this. You can't have any contact with the victim. I find out you do, you'll sit it out in jail until we can get around to it. And no one on your behalf tries to influence the victim. You understand?
Yes, sir.
If I find out, I just found out the other day about somebody and they're gone. They're sitting in jail until we can get their mess fixed. But serious injuries like that, generally, it's not proven that they beat themselves in the face with a stick, with a board. Generally, somebody caused it, and the grand jury says it's you. All right, anything else to add? Let's get this thing to trial. It sounds like this one could be quick. Let's move it fast track it. Thank you.
Sure. Thank you.
Next. Who's up? Who's left?
We have a
Forgot to write a reset on yours. Justin Walker has a new attorney and I reset it. Quick turnaround for that one. And I think I already put the file, maybe, you know.
There's Justin Walker.
Okay, thank you for Wilkins too. You still have.
Okay, on Willard, we took care of Willard's?
Yes.
Yes, sir.
Okay, I have, give you that,
Thank you.
and Lorenzo Walker, we just took it to that. Okay. Then I have. Inslee. And Elia Martin, what did we do on that?
It's an initial setting.
We haven't dealt with that one.
No.
Justin Walker.
Reset. You already had it. And I'm at Bernard Williams.
David Davis.
That's the add-on that you asked me to bring to court today.
Okay, we still need to that. I have Vernon Williams.
I need that one.
That's been done. Okay, yours is
Braden Hensley, Your Honor.
Hensley.
And
Come on up.
I do have one additional witness in addition to the defendant. So.
Okay, hold on. Let me get this set here.
Yes, sir.
On 24 CR 515, the state of Texas versus Braden Hensley. That's you, sir.
Yes, sir.
Present with your attorney, Mr. Wilkerson, the state's attorney. And earlier you entered a plea of guilty to the third degree felony of illegal possession of child pornography. Is that correct?
Yes.
And that was done, is that May 18th, last week, month? A pre-sentence report has been prepared. Have the parties had an opportunity to review it? Are there any corrections or changes to it?
None from the defense, Your Honor.
None, Your Honor.
It's been made a part of the record for all purposes. Okay, what did you, How did you want to proceed on this?
Judge, I have two witnesses, one being the defendant himself and one being the defendant's mother. I don't know if you want a question here at the bench or have a seat at council table. And...
We can do it here.
Okay.
Where's his mother? Okay. Why don't you exit like we do on witnesses under the rule of sequestration? Because I don't know what she's going to say or he's going to say, but we don't want to have a risk of, okay, I heard what he said, I'll just say what he says.
Yes, sir.
All right, raise your right hand, sir. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. Go ahead.
Mr. Anstey, the offense date on this was April 4th of 2023. Is that correct?
Yes, sir.
November 4th.
November 4th.
I'm sorry. November 4th of 2023. Prior to that, you had been on probation in Hardin County. Is that correct?
Or
I was
It's in your PSI. John.
I know.
I'm sorry.
it was possession of controlled substance.
We're gonna let him do this speaking. You'll listen.
It was possession of controlled substance and burglary.
What was the controlled substance?
It was ecstasy.
Mm-hmm. Where were you acquiring that from?
It was a dude I went to high school with.
Keep going.
All right. You were required to go to ISF.
Hold on. Before we. What about this 5 years probation for burglary of habitation? That was at the same time.
Yeah, they both gotten combined, I guess, because of COVID. That's when both of them,
that's when those were disposed. They were disposed on the same date, January 23.
Yes, sir.
And then you were revoked, sentenced to 3 years imprisonment on June 5th of 2024.
Yes, sir.
Why were you revoked?
Because I couldn't. I kept.
Of this case?
Sir?
Because of this case?
No, sir.
No, because that would. That could have worked, but under the timing of it all. But what were the reasons you were revoked?
I was revoked because I kept failing my UAs for alcohol. Yes, sir. And then I had went to ISF. I had come home, and then no sooner or later I came home. I failed another UA for alcohol, and then got my probation revoked. Went to TDC, and that was I don't know, that made me realize my freedom and how much my decision making was back then was, I mean, it just was very poor. And you were you abusing alcohol severely? Yes, I was. And was that disinhibiting? You weren't considering consequences of your actions at the time? No, I was not.
How old are you right now?
23.
Go ahead.
You were then sentenced, as you indicated, to 3 years TDC. Tell us what you learned from that experience. So I just learned that all of my consequences always have actions. It doesn't matter what I'm doing right then and there. I always have to worry about in the future, and not only who am I affecting, me myself, just the other people around me. I've learned that's just me as a person. I'm trying to work on it, and that going to TDC and coming home, and now.
How long were you in prison?
I was just a little bit over a year and a half. So since then, you've been on parole. Is that correct? Yes, sir. Have you experienced any problems with parole? No, sir. Just before you went to TDC is when you were arrested on this case. Is that correct? I wasn't arrested on it. That's when the phone was discovered with my old job. And as I was awaiting to go to ISF, that's when I guess it went to. This case was indicted in March of 2024, to the best of your recollection. Is that correct? I thought it was at 23. Well, okay. So the offense date was in November of 23, right? Yeah. When the phone was picked up and you were waiting to go to, you said, that was ISF at the time, right? The phone was discovered when you went to ISF.
Yes, sir.
And then you came back, you messed up, you went back to prison, correct?
Yes,
Did you post a bond in this case?
I did. Yes, sir.
And so that only gave you a 2 days credit, is that correct?
Yes.
And so while you were on bond is when you served TDC time on your Hardin County offenses, is that correct?
Yes, sir.
All right. Now, with regard to the nature of this offense, do you understand the severity?
Yes, sir, I did.
Can you tell the court in your own words, in terms of victimization, what you realize now that didn't seem to strike you back then?
Back then, I guess I just had my not necessarily. I mean, it was fantasies. I guess at the time it was kind of twisted. I didn't realize the way I see things now is. I mean, I don't want to bring it up here, but I will. I have a 4-year-old sister now. I look at her as as she's my own daughter. I mean, I could never imagine anything bad ever happening to her. And if it did, I mean, it would really affect me. And I just know that this right here is, I know it's a speed bump. It's something that, I've done. I don't know how else.
In this,
I hate all of it. I want to just, I apologize.
In this case, you understand that the court has a number of options, correct?
Yes, sir.
You understand that whether you are sentenced to TDC and later paroled or you're offered probation here, you're going to have to comply with sex offender terms, including registration.
Yes, sir.
Do you understand why the court would have concerns about you being around your sister unsupervised?
Of course, but she would never be unsupervised. My mom and her father, my stepdad, is always there at the house, or she's at daycare during the day. So,
and do you understand that one of the things that the court could do is send you to home confinement for a portion of probation, or do you understand that the court could place you outside of your home until your counselor and completion of chaperone training by your mom and your stepfather completed in order that all proper precautions were taken?
Yes, sir.
You talked about, having a sister now and imagining something bad happened to her. In terms of, is that the way that you have personalized the victimization that the kids in these other images?
I think anybody, if they had a picture of my sister that was any sort of way that's wrong looking, I think that is the most. I realize that now that is the most wrong thing. It's sick. It's just messed up.
Oh, wait. Well, what caused you to have a feeling of that now? You didn't have a problem victimizing all these children in these pictures then. I mean, they're children, like your sister.
Mm-hmm.
Well, why couldn't you see a comparison? Why didn't you have empathy for them then?
No, I wish I had an answer for that.
That doesn't make sense to me.
I see her now, and it's been an eye opener these last 4, almost 5 years.
The use of alcohol in your life, did it numb?
Yes, it did.
Was the alcohol voluntarily taken?
Yes.
Or did somebody force you to drink?
No, sir. No, it was voluntarily.
All right.
Would you agree that you have had a problem with substance abuse?
Yes, sir, I have.
Would you agree that much like addiction, these issues, if not treated properly, can rise again? I think they could, yes, but you don't foresee that happening? Not in this situation. You understand that sex offender conditions could include prohibitions from being online, limitation on the kinds of phones you can have, and you understand that there can be polygraphs taken during probation sessions, and that you would have to attend sex offender counseling. Yes, sir. If you would not have made bond in this case, you would currently have some time. You said you spent about a year in TDC, is that correct? Yes, sir, about a year and a half. Before you paroled out?
Just 1 second, Mr. Can you tell the jury we're going to need just a little more time? Thank them for their patience. 10 or 15. Thank you. Go.
And so, if you had not bonded out in this case, you would have about a year and a half back time at present. Yes, sir. But because you were on bond, no time accrued toward this case, correct? Yes, sir.
Yeah.
No idea. I just walked in. But
Yeah, find out what they need.
Okay.
Because I got a jury out there.
You also have the guy in jail we need to deal with.
In terms of, you've talked about putting who you were in your past behind you. You talked about putting who you were in your past behind you. Tell the court about your efforts to essentially to rehabilitate yourself and what your life has been like over the last 10 months. I've been employed this entire time, so I'm trying to work as much as possible. Just completed my first semester at Lamar State College in Port Arthur for audio engineering. So I am trying to work on my education and just try to stay focused and, you know, not get involved with drinking or smoking or anything that I was involved with in the past. I really am. I have been since I've been home, trying to give my life a second chance. And with regard to that, trying to give your life a second chance, as you suggest, you've had no problems while you've been on parole. That's correct. All right. And so we're looking at. You understand that the court could also sentence you to up to 7 years in conjunction with our agreement. So are you asking the court to, in part because of the time that you've already served that hasn't counted toward this case and based on your efforts that you've described, to give you an opportunity to complete sex offender counseling and be placed on community supervision?
Is he doing any sex offender counseling now?
At present, not that I'm aware of.
Okay, go ahead.
Would you comply with all terms that the court would order for you? Of course, yes, sir. And is that reflected, do you believe, in how you've handled parole since you've been out this time, since you were discharged, since you were paroled out? Yeah. Yes, sir. Was seeing prison enough to set you straight, so to speak? Yes. Yes, it has. I'll pass it to you.
Oh, I've got a few things.
Go ahead.
So since you're under oath, let's start with what steps have you taken since you got released to address these issues that you're asking the court to deal with? In other words, what have you done on your own?
Just going to school and working. I mean, I haven't done any sex offender classes or anything like that.
So you haven't addressed that issue yourself, right?
No, sir.
No, but you're asking and you're relying upon the fact that you're going to go ahead and do that if this court grants you probation.
Yes, sir.
Yet you've been out of custody for how long?
Just a little bit over a year.
Over a year. Over a year, you have not addressed the problem on your own.
Yes, sir.
All right. Number two, I want you to recognize that the judge did you a great favor and asking your mother to be absent from the courtroom. It's going to allow me to ask you some questions about the information that's on your phone. I'm prefacing that before we get started. You and I both know what's on there.
Okay, sir.
The court has read some to some degree, but it's not given the detail of what actual pictures you were taking of your mom. Your mom is here to testify as a character witness for you. Is she aware of the information that you have on your phone?
Not about her, but
No, I want to know specifically about her. Does she know what kind of pictures you were taking of her?
She knew that I had pictures of her, not to that extent. No, sir.
Are you prepared for her to hear that? Because if she testifies, I'm going to be telling her about that.
Yes, sir.
All right. I'm going to give you a chance to tell the judge what's in this deal that not only one of the witnesses provided in discovery, but an officer detailed in his report about the images you have of your mother. Go ahead and tell him.
I had pictures of my mother just around the house.
Be specific, sir.
I had stolen her underwear at times. Did acts with her underwear. Yeah.
He's a big person. He knows the words. Tell him.
I ejaculate on her underwear and just sneaking behind her, taking just pictures of her. Yeah, it was like a sexual thing. Yeah.
And when was this?
This is all.
What period of time are we talking about?
So this would have been during high school and just a little bit right after.
This is you're charged with this offense on or about November 4th of 2023.
Yes, ma'am.
When in relation to that date were you doing this? We're talking about with your mom, as using your mom as a fantasy tool.
Up until about a year before that whole time until I got everything came out.
And all those things were at least occurred during the time in which you were on probation.
Yes, sir.
For two crimes.
For two crimes. You had over 100 images of you with videos of you masturbating, ejaculating on your mother's underwear, specific videos of you masturbating in the back seat while she's driving.
Yes.
All in a work phone underneath a folder labeled mom so that you could have easy access to know what that was to continue your sick fantasies.
You have to speak out.
Yes, sir.
And you've never addressed that, yet you are relying upon this court to the suggestion that he could give you probation and send you to live with her and your sister that you're describing as someone that you really love and care for.
Yes, sir.
Do you not love and care for your mother?
I do.
Do you not see the problem here?
Yes, sir, I do.
Well, why would you victimize her if you love her? That's kind of hard to put together, isn't it? You don't victimize somebody, you care for them.
Sir.
Oh.
Last thing, Mr. Hensley, when you were talking with the judge, you described all of this as a quote unquote speed bump. I will give you one more opportunity to change that answer.
Yes, sir. I was a sick and twisted individual growing up. I had a lot of bad, inappropriate pictures that I had found on Google. It was definitely not a speed bump, just
Bad choices.
horrible choices. Yes, sir.
But choices nonetheless.
Choices you made, you've continued to, up until today, to try to minimize it, describing it as a speed bump. You tried to minimize that contact when you talked to this PSI officer just a few weeks ago. And You think we should trust you to send you back to fantasize some more about your mother and whatever knows happening to this poor 4-year-old sister of yours?
No, sir. I would like to have some supervision or classes that I can take because.
Yet you've done none of that on your own.
No, sir, I have not.
I have no further questions of this witness.
Anything else?
Mr. Hensley, how old were you in November of 2023?
I would have been 21.
Yeah. And you said that this continued up until about a year prior. Is that correct?
Prior and yeah, until right before that.
I believe in your PSI, you stated that you started collecting images as early as middle school. Is that correct?
Yes, sir, I did.
And in conjunction with, well, first of all, aside from some counselors who work with probation departments, have you? Well, strike that question.
What's that?
Are you asking the court to intensely supervise you for the best interest of the community to ensure in part that these types of acts are no longer being committed?
Yes, sir.
While you believe that these issues would never arise again, would you agree that for the safety of the community, it would be best for that to be verified in some way through sex offender counseling?
Yes, sir.
That's what.
I don't have any other questions of him.
All right. Anybody else?
Yes, I'll call Carrie Marchand.
Who is that?
His mother.
Okay. Have a seat right over there, sir. You like front row, first chair. Thank you. Come forward, please. Oh, that's not great.
You're going under oath.
You're always welcome. You know that.
All right, thank you, appreciate it.
I didn't know if you were thinking we're in a hearing, but you can always come always anytime, as you know. Thank you for doing that. Come forward, please. And raise your right hand. You solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth. So help you God.
Yes.
Lower your hands. Go ahead.
Spell your name.
Spell your name.
Spell my name?
Yes, ma'am.
My first name is Carrie, Carrie. Last name Madushan, Madushan.
You are the mother of Braden Hensley, correct?
Yes.
I want to get one thing that's probably pretty uncomfortable out of the way now. Did you have an opportunity to speak with detectives after the materials were discovered on your son's father?
Yes, one of them called me.
And what did that detective disclose to you with regard to images on the phone that may have involved you? Or were you made aware of images on your son's phone that may have involved you?
He told me that there were images of young women.
Did he
That were on, he said that were on there, images of young girls.
Did he ask you if you wanted to press charges at any point? Or were you asked about that at any point?
He said there was a video of me on there, in a pair of shorts, and asked if I wanted to press charges for that, and I said,
okay. So you're not fully aware of the context of the images that were on.
I never saw them, and he didn't disclose anything because he said that was evidence, and he didn't tell me that. All I know is he said that one was about a year prior, and then the rest of them were from earlier than that.
Alright. You understand what your son's charged for, correct? And you understand that whether it is conditions of probation or conditions of parole at some point, that the court has concerns about him being around his 4-year-old sister. And if the court were to order.
Actually, I'm concerned about any child.
I intend to address that, Your Honor, but, and so if the court were to order that your son be placed outside of the home, at least until such time as you and your husband could undergo chaperone training, would you be able to support your son in that context?
Support, what do you mean by support?
In other words, would you be able to contribute to his him having a residence outside of the home if that were necessary?
Help him pay rent and things like that? Is that
Yes.
what you're asking?
Yes.
That, I don't know. I'd have to sit down and we'd have to figure our finances. My husband and I are trying to, we're wanting to buy a house come December, January, so that will put in there. It's not a thought that I've had.
Okay, let me ask you, do you understand why, with images of young children, there would be concerns about him being around any children?
I wasn't aware there were images of young children. I thought they were girls that were about his same age at that time.
What do you mean by about his same age at that time?
Around, because this was 3 years ago and almost 3 when I was talking. So hectic.
Mm-hmm.
Yeah,
Adults,
Braden.
other adults, young adults.
Yes, and Braden's, he was 21, he had just turned 21. And he said that one image was from the year prior, over about a year, almost January of the previous year is what he said.
When you said.
And then that puts Braden at being 19, 20, so I'm thinking about, I know of one image I saw on Braden's phone accidentally because we had the same type phone and I accidentally took his phone to work one day and he had mine, and his girlfriend at the time, who was a year older than him, he was 16, she was 17. She was an aspiring photographer and she liked to send him pictures and I saw one.
And so was it your belief that all the pictures were of that age?
Yes. Yes. Her and her friends.
So.
Sending him pictures. And I spoke with her mother and stepdad. Hope to try to end this, but.
So, you're not aware that there were images that are described as being with children anywhere from 5 to 10 years of age?
No, don't know anything about that.
With regard to such an offense, are you still asking this court to be lenient with your son and give him some sort of community supervision?
Yes, because I don't feel when Braden is with my daughter, her name's Amaya, Amaya. They're like brother and sister. They play, they do their fist bumps, and Braden's always been an artsy kind of person, like paints and sketching and drawing, and they'll sit at the table and color Pokemon, and he'll take her out and ride bikes, and it's just typical. And they banter back and forth, and he'll pick on her and she picks back, and I don't feel any kind of weird vibe going on there at all from him. And if she's ever in the bathtub, and I pull the door closed, he never, nothing. So I don't have any discomfort there at all.
I can appreciate that. I'm just going to say right now, there are some things you don't know.
I understand that. I understand
we know,
that.
and they're most disturbing.
But I was asked how I felt.
I understand,
that's how I feel.
and you seem like a very nice, wonderful person.
This court just doesn't tolerate the victimization of innocent people. And who does really, reasonable? And this is going to get more disturbing as you stand there. I'm afraid.
Can you tell the court what growth you've seen in Braden since he has been discharged to parole?
He is a different person than he was in his late teens and early 20s. He has a job that he's been working for now for a little more than a year at Nebraska's. He started out as a dishwasher, he's promoted now up to fry cook, got pay increases. He works nearly a 40-hour work week every week. This year, I have another son who's 2 years younger than he is. Started school this spring, and Braden expressed an interest in studying some music classes. So with that, I encouraged him, and he signed up with Lamar State College in Port Arthur. And he took 2 classes, and one was an online class. Braden's not the best with reading, and so he kind of stumbled with that, but he still tried. And he had the other class, which was an American music class that he'd go to Tuesdays and Thursdays. He was there every day.
When you say he's a different person, though, what do you mean by that in terms of changes that you've seen from before prison to after prison?
Before he had to go into prison, he was a little reckless with himself. He got involved with marijuana and drinking, and just a little stupid, crazy. It's the best way that I can explain it.
Just once he was put on probation the first time, and continued, I guess, down this alcohol path. How did you address that? How did you provide support?
Well, in 2021, when Amaya was born, she was born in August. That Christmas, Braden was drinking and got a little carried away with this drinking and alcohol. And it was pretty much the boiling point at that time, and I made him leave the house. Basically, my husband and I, we kicked him out of the house because it was a behavior that I didn't want to be around, he didn't want to be around, and I didn't want it around my newborn.
Your other children?
Well, and my other son had moved out and was living with his girlfriend, so it was just 4 of us. But it was primarily, I don't need this influence, this behavior. You're over 18, you're grown, you need to be, take care of yourself. I can't do this for you anymore.
So is it the case that you don't put up with intolerable behavior?
Yes. I mean, I can excuse some, I can make it excuses, I can rationalize it. But when you constantly just keep doing the same behavior over and over again, I couldn't deal with it anymore. He was yelling, he was screaming. We had people there. It was Christmas.
And would you say that type of behavior was pretty much the norm for him prior to going to prison?
It was like, it wasn't his norm all the time, his whole life. It was just where it had come to a head at that time. But yes, it got to the point where I made him leave the house, and he was basically homeless for almost a year.
And so, do you know what chaperone classes are?
No.
All right. And so do you understand that if, that whether Braden's put on probation or he receives a sentence and then is later, paroled out, that there will be conditions on where he can and can't live and who he can and can't be around in terms of age?
Well, I understand.
All right. And are you willing to complete whatever programs are necessary to ensure that you are properly supervising your daughter around someone who will be a registered sex offender?
Well, yes, of course. I mean, I don't, yes, of course.
And in terms of Braden, right after he was arrested on this charge, he is when he went to prison. Is that correct?
Right. Probation violation.
And that probation violation was at the continued use of alcohol, even after ISO.
Yes.
Is he using alcohol these days?
I do know that he has, but it's rare. It really is. But that he works and he's late. He gets off late in the evenings, and I'm not always awake when he gets home from work. But as far as I know, I mean, it's rare. That's all I can say. I know that he has.
Does Braden show an interest in wanting to be a better person than he used to be?
Oh, yes.
Or that his behaviors, let me say that his behaviors tended to demonstrate?
Well, when I was speaking about him going to class, he really enjoyed taking those music courses. He bought his brother's car because he was wanting a car, so he bought his brother's car. His brother was trying to save money for a trip he was wanting to take, so it was twofold. Brother got money, Braden got a car. But the car's a 2010 Kia Soul, and it needs a little work on it. So he's been learning basic mechanics to fix up his car. And he has expressed to me that he actually really enjoys doing that.
Yeah.
Which I'm happy for. Anything that says, hey, I like doing this, I like working on that, I aim to encourage all that. I mean, that's just me as a person and me as mom too. I want to see him happy. I want to see him succeed. I want to see him moving forward with his life, finally growing up and becoming the adult that he should be.
Do you think that's happening now?
I believe he's finally on that path. I really do believe he's on that.
Do you think it would be in his interest as well as the interest of others to be supervised and continue a pathway of counseling, sobriety, and growth?
I don't see where that would hurt.
Are you asking the support to, in part, because he's already served some time that's not attributable to this case, and because of his support system and the changes that you've noticed in him, to be lenient with him and grant him some sort of community supervision?
Yes.
Has to wait.
Let me just ask you, what about drugs? Are you aware of him misusing drugs?
I know he has a vape, but as far as anything else, I don't. I'm unaware.
You don't know?
I don't. I'm unaware. I haven't noticed the behavior that I noticed several years ago, where he would be slurring speech, constantly consuming any kind of sweet goody, Debbie was his best friend kind of thing. I haven't seen any of that. He's gained weight. He works. I mean, whenever they call him, even if his day off, he'll go to work. And I know if I need any help around the house, he's there. He's there to help.
Okay. Go ahead, Steve.
Thank you, Judge. How long has Mr. Hensley been back?
He was, since he's been released.
From prison?
It was, I want to say it was March of last year.
And that time frame, he's living where?
With me and my husband and our daughter. And now my son's moved back in.
So have you had any structured supervision restrictions placed upon him?
I just like to know where he is.
Has he had unsupervised access with your daughter?
Unsupervised, like babysitting?
Has he been alone with your daughter?
No, because my other son, I've left her home, like if daycare was closed and my husband and I had to work, it's both sons were usually there at the same time. So I don't remember that he's ever been there by himself.
Are you certain?
Not 100%.
Are you concerned?
I'm not concerned. No.
Okay, let's talk about that then. All right. What is the charge that he's here for?
Possession of child pornography.
What does that mean to you?
Well, I know what it sounds like, but for me,
Not what does it sound like? I'm asking, what does it mean to you?
To me.
Yes, ma'am.
for me, it means that he had pictures of young women. That's what I,
Define young women for me.
around his age, 16, 17, 18.
That is not child pornography. You're telling me that whenever you listen to things on the news and you hear about people being in possession of child pornography, every one of those times you've thought it's just young adults?
No, because
That's because that's not what it is, man.
I understand child being someone under the age of 18. That's the way I understand the child. And some are and some are not. Small children and some are not. Some are.
Your son, when he was interviewed, said, I have thousands of screenshots from middle school. They were underage. They were 5 to 10 years old. That's where your lawyer or his lawyer was getting the concept of 5 to 10 years old. He has he has an unaddressed concern for pictures of young children around the age of your daughter. Does it change anything? Now that I've told you that, and I'm just beginning to scrape the surface of what's here. Does it change any of your concerns? Are you concerned at all now that I've told you that?
With relation to my daughter, no. Because I just don't see anything.
All right, so I want to time out there for a moment.
Mm-hmm.
What the lawyer for your son has pitched is that this court ought to consider giving him probation, which means sending him back home to where you live with that child, and you still don't have concerns about him being around her.
No, because when we buy our house, both of my sons won't be living with us. No,
Ma'am, that's not enough.
I really don't. I mean, honestly, I don't, not with regards to my child. I even hearing this, because this is the first time that I'm hearing.
We're going to get into some more disturbing matters, ma'am.
Okay.
Because you've been labeled as part of his support system. And I'm going to be fair with you and tell you that before you were called as a witness, I gave your son an opportunity to tell you what is on this phone before I do. And they chose not to do that. They just called you in here. So that means I'm going to be the one that gets to tell you what's on there.
Okay.
And it's not fun. So two different witnesses have detailed the fact that on his work phone, not personal phone, on his work phone, he had a folder labeled Mom, where he could access photos of you. Those photos were sexually inappropriate.
Stand by. I'm going to mute this part. She doesn't deserve it.
All right, friends, we're not going to sit here in silence. We are in the Wayback Machine just a little bit, so I will bump us forward. While I do that, new friends and old, do me a favor. If you enjoy what you see here and you appreciate the work we put in, please do share this channel with your friends and let them know that we're out here. I'd very much appreciate it. They can find us on YouTube at the Courtroom Files. All right.
Not addressing these things, and today he wants us to address all that, right?
I suppose, yes.
No further questions.
Anything else?
Hearing the things that you've heard, can you ensure that he would have no unsupervised access to his sister, whether that was ordered or not?
Absolutely.
And you understand that if he is granted any form of probation, or even later if he's granted parole, that will likely be a condition.
I understand that, please.
Right. And are you still asking this court to allow him to go into treatment and those services be provided to him through community supervision?
Yes. Because I really would like to see him get some sort of therapy, treatment, education, whatever. I mean, anything that would benefit.
Nothing has prevented that from happening.
I wasn't aware of all the.
He's a grown up.
Exactly.
Not best with.
I don't have any other questions for her. She's been
Who's
victimized
next?
enough.
Anybody next? Anybody?
No, sir.
All right.
No, sir.
Come on up, sir. You may be seated then.
You don't have to leave the quote. You have to sit down.
It's gonna take 10.
The pad?
Yeah, charge it.
All right, before we finish this up, let me ask you, you were on probation for in 2 cases in Hardin County for illegal possession of a controlled substance. What was that?
It was ecstasy.
I'm sorry, ecstasy.
Ecstasy.
And then you were on probation for burglary of a habitation out of Hardin County. Whose home was burglarized? Anybody you know?
It was my grandmother's.
You burglarized your grandmother's home. Is that right?
So
And you were placed on 5 years deferred or unadjudicated probation on each case on January 26, 2023. That was revoked a year and a half later. Both of those, and then you were sentenced to 3 years in prison. For what reasons were those 2 probations revoked?
I kept failing my UAs whenever I would report for probation.
Okay, you were failing your UAs. What were you testing positive for?
Alcohol.
Okay. Sure, we're not missing anything. Do you remember being interviewed by the probation office for this case?
Yes, sir.
Do you remember when that occurred, when you had the interview with the probation office?
Yes, sir.
When?
It was about 2 weeks ago, 2.5 weeks ago.
2 weeks ago? Okay. So other than ecstasy, any other drug problems?
It was ecstasy, marijuana, and alcohol. Those were my.
Okay. How long were you using marijuana?
Up until I was on probation.
How long? I don't know what that means.
2022.
When did you start?
January of 20. Oh, start. I was 15. And
Okay.
2017.
Okay. 9 years?
Yes, 9 years.
8 or 9 years?
Yes, sir.
Where were you getting your marijuana from?
Just whoever I was going to school with, a friend, buddy.
And how frequent was that?
It's probably like once a week.
Weekly for 7 years?
Yes, sir. Yes, sir.
Did your mom know about that?
Yes, sir. She did.
She knew you were using marijuana weekly, committing a crime every week, 52 weeks a year,
sir.
times 6, 7, 300 times?
Yes, sir. That's why she kicked me out of the house.
When did she, after 6 years of finding out that?
Yes, sir.
And nobody, so y'all knew about problems here, but you didn't go treatment for that, right?
I just. No,
You're
sir.
committing a crime each time you do that. That's 300 some odd crimes. Okay. You're free falling. This is just free falling in all kinds of ways, isn't it? Oh. If nothing further, earlier you pleaded guilty in this case voluntarily. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of this 3rd-degree felony of illegal possession of child pornography. And again, these are crimes. This is a crime that
is alleged to have been committed after you were placed on probation in two felony cases out of Hardin County. And you made promises when you were on probation that you would follow the rules. The first rule in all probation terms is do not commit other offenses. And so you are charged with committing this on or about November 4th, 2023, after you had been placed on probation in those two cases. Then your probation were revoked for what reasons again? It wasn't for this illegal possession of child pornography, was it?
He
It was
states
something else altogether.
failed UAs is what he's
Yeah.
saying.
Yeah, you were failing the drug tests, so they revoked you for that. Illegal possession of child pornography is just not a simplification of a crime. It's not simple. Every child image portrayed in any image is a victim of that. And we are talking about multiple victims of children. Plus, we know now you even go so far to victimize your own mother in this. Yeah, you need some help. But this is something that you should have received help for a long time ago. Not here, after you're placed on probation in another case. And you're still, on the one hand, trying to make amends for the two crimes you were placed on probation for in Hardin County, and then you're on the other side committing crime all the time, daily, for the child pornography. I don't feel sorry for you. I feel sorry for these children. That's who I feel. What is the price of the innocence of a child when they are victimized in pornography, and then that pornography is possessed or traded or used? That child is a victim over and over and over again. What is the value of the loss of innocence of a child? You can't put a price on it, because I've got 2 children and 3 grandchildren. I couldn't imagine the harm. But I've done this for 20 years. I've been a lawyer for 40 years, and I've dealt with child pornography. It is maybe the worst, because children just, when they're victimized, they have a hard time ever becoming what we want in a normal life, because it haunts them forever. It's not something you can just shrug off and forget about. You used it for your prurient pleasures. That was terrible, sinful crime. I now find you guilty beyond a reasonable doubt of this 3rd-degree felony of illegal possession of child pornography. I am following this agreement. You are hereby sentenced to confinement in the Institutional Division of the Texas Department of Criminal Justice to serve a term of 7 years. This seems like that's not severe enough for what you have pulled in crimes. This is now your 3rd felony. It's a different type of felony, but this one is innumerable children and family have been victimized by you. You need to fix that. You can fix it on your own if you want. I don't have to force you into probation. You'll be paroled soon enough. The parole authorities hopefully will work with you. But at the end of the day, all of this is your choice making. You're going to decide what kind of life you want to live for the rest of your life. Is it going to be atonement and trying to do better? Or will it be continuing to fall back on your prurient interest, which victimizes others? This is a simple choice to make. Do the right thing. You can start anytime, but do it and stay on the path. But you have victims that you have to pay for. And that's what this is all about. That's what we call justice. That is all.
So a couple of things to note there, friends. First, that was charged as a third-degree felony, so you're not going to get the decades that some of you are probably seeking. But this is more than we often see. So often with these kind of cases, it's like 3 years probation and a coupon for a free dinner at the Sizzler that night. So take what you can get, I suppose. Thanks for hanging with me for an additional 4th hour today. I wasn't going to leave that in the middle, so I hope you all enjoyed it. New friends and old alike, if you enjoy what we do here, if you appreciate what we do here, please do share this channel with other people that you know and help us grow. We would appreciate that. We'll be back tomorrow morning, 9 a.m. Eastern, 6 a.m. Pacific. If you're a channel member, you can join me a half an hour earlier for the pre-show. And a reminder that tomorrow night, Sidebar, 8 p.m. Eastern, 5 p.m. Pacific. Tomorrow night is the You Decide the Topic night. So be thinking about what you want us to talk about and bring it to the show with you so we can do that. The wisdom I leave you with for today comes to us from Henry Ward Beecher. Hold yourself responsible for a higher standard than anybody else expects of you. We will see you all tomorrow. Go have yourselves a good day. Take care. God bless.